Which one was that? Say again.
Judgment.
Judgment.
For reasons mentioned in the judgment, the criminal petition number 1205/22, as well as criminal petition number 1193/22 are allowed, and the charge sheet number 73/21 and charge sheet number 231/22 are hereby set aside and quashed.
Back to mention item number 17 of today's lecture also. 1717. The prayer from the petitioner said that we're going to withdraw this application. It may come up on 4th of April for withdrawal.
For withdrawal
For withdrawal on 4th.
on request of Mr. R.P. Hajorika, learned counsel for the
17, no?
petitioner.
17, item number 17.
17.
Case diary is here.
Let this matter be listed on 4th of April.
4th of April.
The case diary may be retained till that day.
Deeply obliged.
May it please your lordship. I am praying for listing of a bail application on tomorrow, my lordship. Matter is supposed to be listed today, lordship. Unfortunately, this is not in the list, lordship.
Matter relates to what?
Relates
what is the
to,
offence?
less than 7 years, and there is a special act, lordship.
It is a special act.
Yes, lordship. As per roster, this bench is available for this case only.
Which special act?
There is,
Because for special act, there is a senior court.
Assam Cattle Preservation Act, lordship.
Justice Obin.
As per roster, this bench also taken this. Deeply.
No, but also taking will not do.
Senior bench.
If a senior bench is taking, then you have to mention before the senior
Lordship,
court.
this is section is 379. This is 3 years
Less
imprisonment.
than 7 years.
Yes, Lord.
Okay.
Deeply obliged.
I beg to mention for listing on AB mail.
Matter relates to,
Matter 380 mail. Under section 380 IPC.
okay, when?
And day after tomorrow.
Why you have to mention? Otherwise, in normal course, when it will be listed, when you have filed it.
Yesterday, man.
Otherwise, when it will be listed in normal course.
And normal.
Normal course also, it will be listed within 2-3 days.
Some important, sorry, some emergency.
Okay, okay.
Maybe, Your Lordship. I like to mention item number 28, Your Lordship. Kindly matter be taken up at 2, Your Lordship.
Okay.
Thank you. Deeply obliged.
Lordship, with the consent of the other side, I beg to mention item 31 of today's daily list. Lordship, the conducting counsel is in bereavement, Lordship.
Miss
Lordship, P.
P. Borua, learned counsel for the
Lordship, I'm appearing on behalf of Mr. M. Islam, Lordship.
learned counsel submitting on behalf of Mr. M. Islam, learned counsel for the petitioner who prays for an adjournment on the ground that the conducting counsel is in bereavement. Learned counsel has also submitted that she has obtained the consent of learned counsel for the respondent side. Considering the submissions, the prayer is allowed. Let this matter be listed
Lordship,
after 2 weeks.
Lordship, deeply obliged.
May I please, Lordship, with respect to item number 9, can kindly be adjourned for today and listed either tomorrow or day after tomorrow. Because of medical reason, the arguing counsel had to move to Calcutta.
Item number 9.
Yes, Your Lordship.
Case diary is here. Case diary is here.
It is there.
It's a criminal petition.
Okay. Heard Mr.
R. Chaudhary.
R. Chaudhary, learned counsel for the petitioner who prays for an adjournment on the ground of medical urgency. Considering the submissions, the prayer is allowed. Let this matter be listed on
Lordship, tomorrow, day after tomorrow.
4th of April.
Much okay.
My lord, this matter is earlier rejected by your lordship, my lord. I have filed it again, my lord. Kindly list for tomorrow, my lord.
When have you filed?
Yesterday, my lord. Kindly tomorrow. Oh, bless.
It is a lordship. Malad 439 application, the charge sheet has been filed. He is facing trial malad with the Court of Language Sessions Judge at Karimganj. So at this stage, my prayer lordship, if the NCR trial court record along with the case diary was called for malad.
22C, let the case diary and the LCR.
Heard Mr. M.A. Chaudhary, learned counsel for the petitioner, also heard Ms. S. Jahan, learned additional public prosecutor. Let the scan copy of the case record of special NDPS case number 7/2023, along with scan copy of the case diary of Bajari Chera PS case number 17/2023 be requisitioned from the court of learned. Which court it is pending?
Sessions Judge Karimganj malad.
Court of Learned Special Judge Karimganj. Registry to take steps for requisitioning the aforementioned scan copies. Let this matter be listed after the 25th on 25th April.
25th, deeply approved.
Yeah, big Lordship. My lord, this is a 439 application, my lord. My lord, petitioner behind the bar for last 10 days, my lord. 47, my lord. Some amount of some cartoon recently, my lord, recovered from my house, my lord. This is a admitted fact, my lord. These cartoon were bought due to my elder sister, my lord, marriage ceremony, my lord. But the police seized the cartoon, my lord. Then they put section, my lord, 317 on, my lord. 317 on, my lord, how will come, my lord? Because my lord, I purchased from the wine shop, my lord. So, for my sister marriage ceremony, my lord. My FI is page number 17, my lord. My lord.
There is
It's
no
a
reason.
shop.
My lord, 10 days, my lord.
It's a shop which is selling those illegal.
No, my lord, these are allegation, my lord. In the village, my lord, there is no wine shop.
Why
there.
your prayer was rejected by the trial court?
My lord,
Why your prayer was, whether your prayer was rejected?
there is, my lord, very first day, my lord. Therefore, my lord.
Where is the rejection order?
Rejection, no, my lord. I have not a next, my lord.
You have to annex it.
Hmm.
Now, you must know the rules.
My lord, already, my lord, 10 days, my lord, for.
No, I understand, but the requirement is that rejection order has to be annexed along with bail.
Moreover, my lord, but the landed court below, my lord, did not send to the me, my lord, for police remand, my lord, because landed
I am
court-
not hearing anything
lord.
unless you annex the rejection.
He
order.
can file an additional affidavit annexing that.
Then, my lord,
Meanwhile, we'll call for the case diary.
my lord, at least only the 10 days, my lord, what I have suffered, my lord.
You will not annex the rejection order.
Yes,
Should-
no, my lord, because this is the very first day, my lord, therefore I sent to the judicial custody, my lord. Otherwise, if something is there, my lord, they forwarded to my lord, police custody, my lord. Very first day, my lord, I forwarded to the
Yes,
judicial
Mr.
custody, my lord.
But then the order is a
Order
requirement
has-
under the
My
notification, I
lord,
think.
if they impose any condition, my lord,
I will dismiss this case for non-following the
my lord.
requirement of the notification.
File an additional affidavit.
Lordship may fix on 9, my lord. I will get it. And also call for the case diary. My lord. Very genuine case, my lord.
You will file an additional affidavit.
My lord. I'll file.
Heard learned counsel for the petitioner. Mr.
My lord, D. Google. On
Mr.
behalf of
D. Google,
President.
learned counsel for the petitioner who prays for allowing him to file an additional affidavit to bring on record the rejection order by the, which court has rejected?
My lord, Chief Judicial Magistrate, Dhemaji, my lord.
Chief Judicial Magistrate Dhamagi.
My lord.
Stop. Perusal of the case diary would also be necessary, hence call for the case diary.
I pay for 9, my lord.
9.
My lord.
Leave this matter again on 9th of
My lord.
April.
My lord. Hello, bless.
Before that, you have to file your additional
I'll
affidavit.
file. Hello, bless.
My lord, may I please your lordship, my lord? In this case, my lord, what happened, my lord? I was behind the bar for, my lord, 45 days, my lord.
For
45 days, my lord. I was arrested on 18/2/2024, my lord. Before, my lord, I mentioned, my lord, but I was not annexed. The rejection order is available with me, my lord. Subsequently got a rejection order, my lord. And I was also, my lord, subsequently engaged in this case, my lord.
you have to annex the rejection order.
Yes,
That is
my
the
lord,
requirement.
That is, I shall engage. The only thing is, sir, my lord, as per my instruction, my lord, annual Sadda ceremony on 12 April. Your lordship may fix the date, my lord. In the meantime, I shall file a decision and CD may be called for, my.
Yes, lordship.
Okay, heard Mr. N.N.B. Chaudhary, learned counsel for the petitioner, who prays for allowing the petitioner to file an additional affidavit to bring on record the rejection order of the bail preferred by the petitioner earlier. Perusal of the case diary would be necessary. Hence, call for the case diary of DRI case number 23/CL/IMP/PS and BP/DRI/GZU/2324. When can you produce the case diary?
Lordship, after verification.
My lord, that is, otherwise I can argue my law point. 41A notice was not served, my lord.
Okay,
I am
so
getting, I
we
can
have some
further
urgency.
order also, my lord.
Let it be fixed on 9th.
Okay, lordship.
Let this matter be listed again on 9th of April.
Macham.
May it please your lordship, Mr. P. Wadler is appearing in this matter, your lordship. May I pray that the matter may be taken up after some time.
Now let us see. What is the matter?
Even I don't have the papers, our office has not furnished.
Whether case diary would be required?
Even I don't have papers, our office has not furnished. Lordship will take it up after some time.
Sorry.
43 or not?
May it please your lordship, my lord, I am obliged to you, my lord, highly obliged to your lordship's kind indulgence that this matter is listed today.
Paper sheets. Yes.
My lord, what is, if lordships look at the FIR, my lord, if I can read the FIR at page, my lord, 13.
Page?
The Assamese version is at 13 and the translation is in page 10, my lord. If I can read the translation.
Yes.
With due respect, I beg to state that we have a petrol pump, namely Shivam service station at Khata Rupia Bathan. Since there was scarcity of fund for running the aforesaid petrol pump, my husband, namely Shri Janakeswar Talukdar, and brother-in-law, namely Jivaneswar Talukdar, borrowed a sum of rupees 5 lakhs on interest at the rate of 5%. The borrowed sum of rupees, they borrowed a sum of rupees 10 lakhs again from the aforesaid accused in the year 2020. Since then, the interest has been paid, and in case interest was not paid in a particular month, the interest for the said month was added with the principal amount. This way, the interest was paid till the month of April 2023, and interest amount was paid more than the principal amount. Since the interest was not paid since 2023, they are continuously forced by the accused. So there is a situation arising of my husband and brother-in-law of committing suicide because of the accused person. They have not committed suicide. They said the situation has arisen. Now the accused has come to occupy a plot of land by demanding that he would get rupees 29 lakhs in return on 29 March 2024 at noon. The accused has taken away my brother-in-law, namely Jivaneswar, from his residence, and second brother-in-law, namely Jyotish Talukdar, from Nalbari, to Belsar by his car. It is to be mentioned that the aforesaid brother-in-law has been bedridden. After that, the aforesaid accused came to take my elder brother-in-law, namely Jagadish Talukdar, and my husband, namely Janakeswar Talukdar, and forced them to hand over the land documents by signing the stamp papers to the accused. As denied for signing the stamp papers, the accused threatened that he would kill us. It is to be mentioned herein that the aforesaid accused forcibly took many signed papers of check. This aforesaid pages of checks in the name of Shivam service station. So I request to kindly take appropriate actions. Next page, my lord. Received and registered by Belsor PS case number so and so under section 420, 387, 506 IPC, read with section 7C2 of the Assam Money Lenders. Now, my lord, in my respectful submission, if hereafter lordship will kindly come to the annexure to money receipt. What happened, my lord? One of their brothers, Nam Jogeshwar Talukdar, he was seriously sick, and for his treatment, his wife, Srimati Gitima Talukdar, took 30 lakhs rupees from this person. And they were very good friends at times. He arranged this much of money for his treatment. He died in the year 2020. Before that, her wife, Mrs. Gitima Talukdar, executed this money receipt, kindly similar. I, Srimati Mrs. Gitima Talukdar, wife of Jogeshwar Talukdar, resident of so-and-so, do hereby acknowledge the receipt of a sum of rupees 30 lakhs taken on several dates during 2018 to January 2020 from Anwar Hussain, son of K. Sheikh of village Rupia Bathan Gaon, PS Belchar so-and-so, Assam, on account of medical treatment of my husband, Shri Jogeshwar Talukdar, who is still under treatment of her various ailment. I promise that if we cannot return the money taken from Shri Anwar Hussain, then we will sell a plot of land from the share of my husband's ancestral land covered by patta number so-and-so, duck number so-and-so. This was executed on 3rd January 2020. Now, my lord will say, why this, even if this FIR to be treated to be true on the day, if lordship presumes that, okay, whatever stated in the FIR is correct, then also there is no case. I'm showing to your lordship. Kindly see page annexure 3. This is the sale permission, my lord. And your lordship is aware, my friend is also aware that nowadays, land sale permission, if all the pattatars does not go to the land along with the mandal, and if you do not take the photographs of the spot, then they cannot get the land sale permission. See this land sale permission, my lord. They signed, all the brothers signed. Then Anwar Hussain took the sale permission in the name of her and of his wife, Srimati Mukuta Begum. And kindly see, this is the sale permission at page 16. And the photocopy is at page 18. Then they kindly see the Mohorar, means the advocate's clerk, he took appointment at page 20, lordship see, for registration. Pre-registration summary, lordship will see, and the token number for appropriate registration. And kindly see the application acknowledgement at page 22. Even after this, if somebody files an FIR and says that I am forced, they are forced to execute a land sale deed, nobody will believe, and it's not a believable story at all. My lord will see. Assam Money Lenders Act, my lord, 7C. Assam Money Lenders Act 7C. In the Principal Act in section 7C. Has your lordship got it, my lord?
Yes.
For the subsection 2, the following shall be substituted. Whoever contravenes the provision of subsection 1 shall be punishable for the first offense with fine, which may extend to rupees 30,000, and for a second or subsequent offense with fines, which may extend up to rupees 60,000. It is a provision of sentence, my lord. Imprisonment. It's absolutely a bailable offense, my lord. And there is no ingredient, even if this FIR, I pray before your lordship, my lord, to presume this FIR is to be true, it's the ingredient of 387.
387 K?
The FIR is registered on the
387 K?
Force,
Extortion.
no, yeah. Putting in fear for extortion. They agreed, they themselves signed in the FIR that we received this much of amount. Fine, I gave it on interest. If I gave it on interest, this is an offense under Moneylenders Act, which is bailable. Or one of our family members executed a money receipt saying that, yes, I took 30 lakhs rupees from Mr. So-and-so on the need of my medical treatment of my husband. And we agree to execute this deed. Or kindly see, my lord. In petition, lordship will see, my lord. I'm sorry. They have signed the sale deed, my lord. Kindly see it.
Why your prayer was rejected?
My lord, this was on the first day, my lord, he was arrested on 29.
Where is the rejection order?
Rejection order, my lord, I applied it. I could not get it yesterday because the court was on holiday.
But
Saturday, Sunday.
that is the requirement.
Again, an additional affidavit.
No, my lord will appreciate, my lord. If the
No.
FIR itself is
Now
not,
you know the notification issued by High Court in pursuant to the,
my lord, I understand,
Direction.
but my respectful prayer with your lordship would be, my lord.
but you have to follow the procedures.
What is my prayer, lordship, at least, my lord, appreciate that. My respectful prayer, my lord, yes, notification is there, but sometimes considering the facts and situation, the rigidity of law may be kindly tempered with mercy, my lord. Because this man,
No, unless you produce that rejection order, how will we appreciate that on what ground your prayer was rejected by the trial court?
my lord, for a moment, if
Okay.
lordship considers the no bail petition was moved there, he was produced and sent to custody, judicial custody. Then also, my lord, that if lordship goes, the record that I have produced, if, and the FIR your lordship has gone into, presume it to be true, my lord. Even then it does not constitute the offense, my lord. Then why and how a person's liberty can be curtailed? But the stroke
No,
of
the
somebody's
allegation is that you force them to hand over land documents, but
and kindly see the sale permission. On contrary to that, only because that somebody writes something in the piece of paper, which has been registered as a FIR, the subsequent document is not supported, it's a government document. My lord, nowadays to get land sale permission is equivalent to get IS examination clearance.
Moreover, they have said that they have signed the papers,
Ah,
but
they
in
have
the
signed-
FIR,
no,
but in the
you
FIR,
have
it's
to
written.
follow the procedure. The
lord-
rejection order has to be there.
My lord, I understand, my lord. I bow down what has fallen from your lordship, my lord. But what my respectful submission and prayer before your lordship, when this rigidity of this notification, whether it can be bypassed in facts and situation, it clearly shows that's an illegal detention, my lord, illegal detention. My lord.
Now
Absolutely.
to appreciate your submissions, that,
Next number.
yes,
That
Ms.
is a
Jahan.
mandatory thing, so if 2 or 3 days
Otherwise-
will not make.
Otherwise, it will never be implemented.
Bells yes.
Everybody will come with same submission
45.
that
But everybody may
Really?
come with same submission, but the situation may not be same.
no, you have to follow the notification. We'll fix a short date.
My lord,
You follow it.
two predicaments on my side, my lord. I'm in bereavement, actually. I have to go to my native place for appearing, attending my Saddha ceremony of my Burma. So I may not be available from tomorrow. At best, I can come back for a while for this case on 5th, my lord.
We'll fix it on 5th.
In the meantime, additional affidavit.
Additional affidavit may.
My lord, but absolutely, if lordship was pleased, my lord, this could have been a example that
I'll not give indulgence to violation of the notifications issued by this High Court. And whether case diary would be required.
In fact, what they have said that they have signed, but in the FIR, it's written that they have not signed. They were just threatened. So maybe there is something of forgery and all. Let him bring the rejection order, then we can decide. And in the meantime, I can bring the CD as well.
You also bring the case diary. Third, Mr. A. Samua, learned counsel for the petitioner. Also had Ms. S. Jahan, learned additional public prosecutor. Ms. learned counsel for the petitioner prayed for filing an additional affidavit to bring on record the rejection order of the bail Stop. Perusal of the case diary would also be necessary for consideration of the instant bail application. Hence, call for the case diary. When can we?
Fifth,
see?
he said,
Fifth.
well, sir, I'll bring it.
Okay.
Friday.
Okay. Let this case be listed again on 5th of April.
5th of April.
On Friday, huh? Hey, Annie Diana.
Ma'am. In this case, what happened, an FIR was lost in 2014.
2000?
Page 34, I don't know. 33, my lord, I have received a summon from the court, Chief Judicial Magistrate, that page 33, your lordship will find. I'll come to that, my lord, later on. Now, page 34, on 11/12/2014, my lord, FIR was raised. Basically, my lord, that the Rahul hired a group of companies. They are, my lord, indulging in, my lord, some quick money and all that. That was the allegations, my lord. May I read, my lord? Rahul Hairaj Limited is registered with ROC Bengal on so and so. Previously, the name of the company was so and so. This is not relevant. The main object of the company is to carry on the business of builders and construction. Otherwise, deal in houses, land, buildings, trade, and any other properties, etc. The main of the company is to carry on the business of so and so and so. Now, my lord, your lordship will kindly see fourth paragraph. That is the allegation. The directors of Rahul Group of Company entered into a criminal conspiracy with one and another. And also with the some other employees of the company, and in pursuance thereof, the said directors launched several deposit schemes, fixed deposit scheme, recurring deposit scheme, and MIS scheme, and widely published among the public by offering high rate of interest and allure the public to invest their money in the said scheme. Now, the allegation is there that there are the three schemes where we are giving the high rate of interest and alluring the public to invest. Now, the directors of Rahul Group of Companies opened several branches of some other part of collected huge amount of public in such a scheme from 2009 to 14, though the company was not obtained any certificate from RBI for taking deposit from public. The director of Rahul Group of Company also raised huge amounts of capital by issuing secured redeemable debentures to the public, for which no certificate of registration from SEBI was obtained, to raise capital nearly 15 crores from the public. The third and second and third allegation is that RBI, no permission from RBI. Second is no permission from SEBI. In respect of the Miller debentures, the director of group company defrauded the investors by cheating and not releasing maturity amount to the investors and misappropriated money collected from the investors and fled away from doing. Now, on the basis of this, case was registered under section 120B 420-406, read with section 4, 5, and 6 of Price Sheet and Money Circulation Scheme, Banning Act 1978, and my lord, it was investigation started. Now, my lord, if your lordship kindly come to page 42, that will be important. My lord, a prayer was made by the investigating officer on 3/9/2019 to aid section 5 of the Assam Protection of Interest of Depositors Act 2013. If your lordship kindly come directly, my lord, to the last paragraph, my lord, I am not reading the entire. And accordingly, my lord, page 43, by order dated 4/9/2019, well, the section, that particular section 5 of the act was not allowed to be not added. Now, in the meantime, finally the charge sheet was filed at page 45 on before the Court of Session Judge. Page 45, your lordship will find. Well, I'm not reading at this stage, because I'm coming to a very short point that my lord will kindly consider. The charge sheet was under section 120B 420-406, 4, 5, and 6 of the Price Sheet and Money Circulation Scheme Banning Act 1978, and section 5 of the that Protection of Depositors Act 2013. Now, my lord, in view of section 6, the only session judge has the power, or any special court constituted for that is empowered to try the offences. So far, section 5 is concerned, not other.
Okay.
Others can be tried by Metropolitan Magistrate or Chief Judicial Magistrate. Now, my lord, your lordship will kindly page 84.
No.
My lord, on receipt of the charge sheet on 5/1/2021, my lord, the lordship will kindly see my name does not appear in this. My lord. 1, 2, 3, 4, 5, 10. In column 10, my lord, 12 accused persons has been forwarded, my lord. Charge sheeted. My name does not appear. Ultimately, my lord, the case was transferred to the additional session judge number 1, Kamrup for disposal. 7/1/2021, my lord, the additional session judge number 1, my lord, pass an order against, my lord, all the 10 persons, not the petitioner. Summon to the accused persons, page 86, my lord, will find. Accordingly, issue summon to the accused persons who are on bail and non-bailable warrant of against the absconders. They were in the charge sheet, my lord, some of the persons were, 5 persons were shown as absconders. Now, the proceeding continued then, my lord. Then, my lord, the charge sheeted, 3 of the charge sheeted persons, some of the charge sheeted persons, my lord, approached this honorable. In the meantime, what happened, my lord, that the Assam Protection of Interest of Depositors in Financial Establishments Repealing Act 2022 was, my lord, passed. My lord, your lordship is page 87.
Which act?
My lord, page 87, my lord, will find. Assam Protection of Interest of Depositors in Financial Establishments Repealing Act 2022.
Okay.
Well, that's section 5, my lord. Basically, I am on section 5 now, my lord, first. Section 5, because of section 5, the matter was, my lord, charge sheet was filed before the, my lord, the Court of Session Judge. It proceeded there. This act was
No,
repealed.
section 5 of the
Assam
earlier act.
Protection, my lord. My lord, yes, my lord, I'll just give. My lord, the 2013 report is there.
This is 2000.
Huh?
This is 2000 act, which is
2000 Act,
repealed.
2000 Act.
But 2013 is mentioned here, no?
2000 is amendment. There is no act.
Oh,
There is an amendment, my lord, I have given to you. You just see.
No, what is your submission now?
My submission here, my lord, section 5, that, my lord, that entire act has been repealed without saving it, without saving any pending inquiry, investigation, or any trial, my lord.
Section 5 of the
5 of the, my lord,
Assam Protection of
Protection
Interest.
of Interest of Depositors in Financial Establishment Act 2000. That has been amended, my lord. Also in 2013, it has been
It is
amended.
repealed in the year 2022 by repealing act. Okay.
Now, my lord, in that, my lord, in the saving clause, pending inquiry, investigation, and trial, my lord, any proceeding has not been saved. We approach this honorable. We are not women. Some other of the charge sheeted.
But you are not charge sheeted.
I was not charged. Now I am coming to that fact.
Okay.
I was not charged. That's what I am pointing to my lord. Now, if your lordship kindly see section, my lord, that act,
Repealing act.
not repealing act, my lord, I am
The
just showing
original
the original act of 2000. Only for the purpose, my lord, my lord, which court has the jurisdiction? So far, section 5 is concerned.
Yes.
My lord, section 5 is notwithstanding anything contained in chapter 2, where any financial establishment defaults the return of the deposit or defaults the payment of interest on the deposit, every person responsible for the management of the affairs of the financial establishment shall be punished if imprisonment for a term which may extend to 10 years, and with fine which extend to 1 lakh of rupees of such financial establishment is also liable to fine for which extend to 1 lakh of rupees. Now, section 6 is important. No court other than the Court of District and Session Judge shall have the jurisdiction in respect of any matter to see the provisions of the section. Any pending case in any other court to which the provision of the act applies shall stand transferred to the Court of District and Session Judge of competent jurisdiction. So, my lord, any offence under this act that has to be, my lord,
Transfer.
cognizance and trial, everything has to be done by the Court of District and Session Judge. later on, in 2013, some amendment has been made. If your lordship kindly take the amendment act, of 2013. Section 5 was also amended.
Where I will find that amendment
I
act?
have given, here only. It is given separate. 2000 amendment act 2005.
Yes, yes.
Lordship got it. Already, your lordship will kindly see page 1100.
1100.
1100, not internal pagination is already there
Yes.
of the act. Now, my lord, section 6. In the principal act, after the word district and session judge, wherever the occur the court, the words punctuation mark or the special court constituted under the act, as the case may be, shall be inserted. So, my lord, by this amendment act or the special court, where the special court is constituted, the special court will, my lord, take up the matter in respect of this act. Now, my lord, section 6 was not amended. Section 6 was not amended. It remained as it is. Oh, yes, yes. It is, my lord, 1104. Last page. For the purpose of speedy disposal of the case under this act, the government may, with the concurrence of the Chief Justice of Guwahati High Court, by notification, constitute one or more special court consisting of a single judge, not below the rank of district and session judge or additional district and session judge for such area or such class or classes of case may be issued as a notification. While trying case of special court under this act, it shall exercise the power, function, and jurisdiction as are available to a district and session judge of the competent jurisdiction. So, the position remains the same.
Now, after the amendment, the offense can be tried by district and session judge or by the special court constituted.
Yes. But that position we don't know, but I am not disputing.
But now that act has been repealed.
Now, we approach this honorable court. The other 3 persons. Your lordship will find this page 89. Repealing act, if your lordship wants to look, my lord, at page 88, my lord.
There is a saving clause also, but then I think for all those things done.
Already, whatever done and over, for that it has been saved. The rest, my lord, it has not been saved. And my lord, now, my lord, few persons who were charge sheeted were facing the, my lord, trial before the sessions judge, my lord. They approach this honorable court. Page 89, the order is. Page 90, the order starts, my lord.
Yes.
Yes, in para 2, 3, and 4, 2 and 3 submission has been recorded. In para 4, page 91, by the repealing act 2022, the entire act 2000 was repealed without saving an action already taken under the act. The other offences under which the charge sheet was filed are under sections 120B, 406, 420, read with sections 4, 5, 6 of PC and MCS B Act 1970 Act, and such offences are triable either by Metropolitan Magistrate or Chief Judicial Magistrate. In that view of the matter, and more particularly in view of the repeal of the Act, the session court will have no jurisdiction to continue with the proceedings. Such fact and contention has also not been disputed by Mr. Barthakur, learned additional public prosecutor of the state of Assam. The learned additional public prosecutor has not disputed the fact of repeal of the Act of 2000 by repealing Act. This court has given answers consideration to the submissions made by the learned counsel of the parties, also perused the materials available on record. Perusal of the provisions of said Act 2000 and repealing Act of 2022 this court is of unhesitated view that offences alleged now shall be triable either by Metropolitan Magistrate or by the Chief Judicial Magistrate. Because, my lord, section 5 is not there. So rest of the whatever, either under the IPC or under the price sheet and money circulation scheme, Act 1978, whatever are there, my lord, those are triable by either Metropolitan Magistrate or Chief Judicial. Chief Metropolitan Magistrate or Chief Judicial Magistrate. The Chief Judicial Kamrup, in as much as offences tribal has already been repealed before framing of charge. In that view of the matter, proceeding of sessions case number pending before the learned additional session judge of Kamrup is directed to be closed and record to be transferred to the learned Chief Judicial Magistrate for proceeding with the matter. Considering the matter in entirety and nature of the offence, this court is of the view. This is not required. There, regarding the non-bailable warrant issues, non-bailable warrants and all that, I have given. Now, my lord, after the order was passed, now, my lord, on page 94, order dated 19/8/2023. Case record is put up before me since the order dated 10/8/2000 passed by the Honorable High Court, whereby it has been directed this court to close the proceedings of the instance case on the ground that the Assam Protection of Interest of Depositors Act has already been repealed by so and so, and further directed the case record transferred to the Court of Learned Chief Judicial Magistrate in view of our proceedings of the case is closed with regard to section 5 of the very specific matter. With regard to section 5 of the Protection of Interest of so and so Act as directed, case record is hereby transferred to the Court of Learned Chief Judicial Magistrate Kamrup dealing so and so. These are my lord administrative orders. Page 95 now. Already having received the case record, CR received on transfer for disposal, peruse the case record, IO of the case has filed charge sheet against the accused persons, namely. Now, my lord, my name appears in this. Susan Pathak, so and so and so and so. Diptendu Banerjee.
What is your name?
Huh?
What is your name?
Diptendu Banerjee, my lord.
He is a declared absconder.
Huh?
Absconder.
In the charge sheet, whether your name figured, original
My lord,
charge
in the
sheet,
charge sheet, my lord, in column 10, my name does not appear.
as an absconder, in charge sheet,
No,
nowhere.
not column 10, my lord. The person who has been, I'll just show to that. Let me finish it. I'll come to
Okay,
that.
okay.
I'll definitely show that. But
Your name appeared for the first time in the order dated 31/8/2020.
my name appeared in the middle of FIR. My name appeared in the FIR. There is no dispute to that.
Okay.
Charge sheet was filed in column 10. My name does not appear. In the other places, my lord, somewhere, my lord, I have been shown. My name is there. But I'll come to that, my lord. Before, let me finish this, my lord. I'll definitely show to my lord. Now, 120B40, 456 of so and so, and section 5 of this Assam Protection of Interest of Depositors Act 2013. On perusal of the entire report and after hearing the learned APP, the same is accepted. In view of the materials available before me, cognizance is taken under the section of offences against the aforesaid accused person. My lord, what I am on, my lord, basically, that my lord, under section 5, the cognizance could not have been taken. This is the first challenge to that. My lord, whether my name appears or does not appear, let us assume that, my lord, in some places my name is mentioned.
Okay.
My basic, my lord, submission before my lord is that
Section
section 5
5
cannot submit.
Okay.
And my lord, even if my lord, section 5 cognizance is taken, Chief Judicial Magistrate is not competent under the law to, my lord, proceed with the trial. And it cannot be sent back in view of the High Court, this honorable court's order. And because of the repeal act. Now, page 96. On 22/1, my lord, having received the summons, I appeared through, my lord, the counsel on 22/1/2004. My lord will find the order at page 96. Accused Kushan Pathak, Shahjahan Ali, Sahar Ali, Abdul Qasim and Rahul Banerjee and Diptendu Banerjee are absent, cause shown. Seen, heard, prayer aloud, and Abhijit Mujumdar and other accused are absent. Summons is returned with report, seen and issue fresh summons against the accused. Now, my lord, here, my lord, in the second limb of my argument, my lord, the date was fixed on that day was 2/4/2024. My lord,
2-2.
2/4, not 2/2, my lord. My lord, that's what, my lord, I have challenged to that also,
But
because
it-
bailable warrant has been issued on 2/2.
2-4.
2/4/2024.
But
If
the
your lordship finds-
order shows that it is 2-2.
Not 2/2, my lord, I'll show to my lord, my lord. Page 98, my lord, will kindly. 98, 99, 98. 98 or support. 98 and 99, 2 pages I have annexed, my lord, the old certified copy. My lord, it can't be read. I'll read. I have given a type copy. 2/4 is there, not 2/2. It has been cut and, my lord, made. Page 98, my lord.
Hmm?
98 is the cut and-
কিন্তু আকৌ টুতে শুনিলে ন?
এবার তুমি কিন্তু নিজে বলে কোনো না হবে না, মজা জানি মানে কেউ মরে গেছে, available warrant কেউ করছে না।
Hmm. 5 of course will not stand, কিন্তু saving clause ত দেখোন অকমান pending proceeding ৰ বস্তু অহা যেন লাগে।
Yes.
But কষ্ট কৰিলো।
Now, my lord, 99, page 99 is, my lord, screenshot. As on, my lord, 24/1/2000, 24/1/2024. If your lordship kindly look into it. Next, the
Hearing
second
date.
part, 2/4/2024.
Next hearing date, 2/4.
No, but this data entry is done by the court staff.
So, my lord, true, my lord,
Then-
my lord. Counsel was present, my lord will kindly see, my lord.
No,
Mr.
but
Das,
the,
Mr.
but
Das
the
was,
order sheets shows that it is 2-2.
no, my lord, order sheet, your lordship will, that has been, my lord, corrected, your lordship will kindly see.
But the next date is also 2/2.
I mean, I'll show the certified copy. It's not a bigger issue, my lord. Since we we know that it is on 2/4/2024. We didn't appear on 2/2/2024.
Okay.
Now, bailable warrant has been issued. There is no larger issue and other things.
Because you saw the
No, my lord,
Fixed
you
date
saw, my
in-
lord, counsel was present. Counsel was
Okay,
present.
otherwise
Date was
all-
given, my lord. Your lordship will,
no, otherwise also in the CIS data,
my lord.
the date is shown as 2-4.
Hmm.
In the e-court data, the screenshot of which you have annexed, the date is shown as 2-4.
2/4. And, my
Therefore,
lord, in fact, the court also said, my lord, the date was given 2/4. Why later on it was changed, my lord? I'm not much on that, my lord. I'm just, because bailable warrant has been issued, that is my only, my lord, I'm saying. And none of the accused appeared on the next day, your lordship will kindly see the next date, 2/2/24.
yes.
Accused Kushan Pathak and other accused are absent. Also, my lord, that type copy I have given.
2/2 type copy is not there.
Yes?
2/2 type copy is not there.
Page
Okay,
100.
then thereafter what happened?
Thereafter, the matter is fixed on 9th.
Okay.
My lord, I have come to basically on 3 grounds. my
Now,
lord.
what is your prayer in this?
My prayer is, my lord, that, my lord, your lordship should examine the matter, my lord, because the cognizance cannot be taken under section 5. In view of the repeal of the act, this is number 1. And in view of the order passed by this honorable court on 10/8/2023. This is first issue. Second issue, bailable warrant issued, not issued, my lord, is not major issue, my lord, your lordship can take, give protection and all that, my lord. And thirdly, my lord, I have challenged the entire proceeding of the case. So far, I am concerned, my lord. And, my lord, your lordship wanted to look into the, my lord, charge sheet. Page 48. Page 48. Page 48, particulars of accused persons charge sheeted, used separate for each accused. 1,
Delay for withdrawal.
2 Shahjahan Ali, 3 Sahar Ali, 4 Dilip Kumar Burman, 5 Marcus Demta, 6 Pavitra Kumar Medhi, 7 Abdul Kasem, 8 Mirmay Bose, 9 Abhijit Majumdar, and 10 Dipankar Gupta.
And there are more. 11.
No, 11 में नहीं है, नील है, 11 में नहीं है. Particulars of accused persons not charged.
Acha.
Where is your name?
Lord, my name in the FIR, and my lord, later on it has been shown.
In the charge sheet?
See.
63, his name appears as an
63, my
absconder.
lord.
It is a part of the charge sheet only.
The column 10 you are not writing, even second judge is not issued the one of current. And it is a transfer proceeding. 63, my name is there, my lord. Serial number 11. Under the column of charge,
So in column number 10,
10 is not there.
your name ought to have been there, but it is
And
not.
your lordship will kindly see, I have shown the order dated 5/1/2021 and 7/1/2021.
Of
Filed
the
by the
session.
session judge and additional session. No, my lord. And my lord, this is a transfer proceeding. The proceeding was transferred from the court of session judge, my lord, to the court of chief judicial magistrate.
Okay.
Of
Now,
course,
what relief you are seeking?
he's challenging the
Entire proceeding.
Let the notice be issued, my lord, let them report to it, my lord, your lordship will examine, because my lord, it will, my lord, under section 456 of the, my lord, this prize money and cheat fund, my lord, this, your lordship, my lord, remember this Stefan Govaj and Saichensa investment case and all that, my lord. All and everything, even PLS case, my lord, also.
Okay, then we will issue notice.
Lordship issue notice, my lord, and in the meantime, my lord, the matter is fixed on 9th. Lordship will further, my lord, stay the proceeding.
The coordinate bench has of course given a finding that that an act is entirely repealed. And
No,
but
the
saving clause,
inclusion of section 5 apparently appears to be wrong.
section 5, yes,
Seems to be wrong.
saving clause is there. Of course, at the first blush, what we can understand is it relates to the proceedings which are already over. But then what I find is even pending proceedings, even the some proceeding for us later, saving clause, a saving clause of the repealing act.
I'm just.
Uh,
Huh? What? 88.
88.
Page 88.
Lordship will see this page 88. Lordship will read the saving clause little slowly. Page 88, 2. Notwithstanding such repeal, under section 2, of course, settled by the coordinate bench. Notwithstanding such repeal under section 2, the validity or effect or consequence of anything already done or suffered, or any right, title, obligation, or liability already acquired, accrued, or incurred, or any remedy or proceeding in respect of any such right, title, obligation, or liability or penalty, claim or demand, etc., already enforced under the Act so repealed, shall be deemed to have been validly done or taken or passed under the corresponding provisions of the Act so repealed. Normally, whatever the saving clauses that we find in so many repealing acts, We find that the pending proceeding will continue as if it has not been repealed. Here, of course, the wordings are little couched in a very difficult way to interpret.
No, but this issue is not before us because now
This
the
issue is not before my lord. I have not raised this issue before my lord.
session court has already, the
Ah,
ordinate bench of this court has already closed the
Yes.
matter pending before session.
And the session court has also sent it to the
Now the
CJM.
question is whether the chief judicial magistrate could have taken cognizance under section 5 or not. That is the,
Hmm.
It is one of the issue, my lord.
but he has the competence of
Other sections.
other.
Other sections, my lord, I'm not, my lord. I'm not saying. My lord, I am also agreeing, my lord, so for the other sections, definitely competency is there.
Normally, it is the other way out. Special court, while hearing on a special law, can go into the other general acts. But special,
General court cannot go into.
cannot.
special.
It's the vice versa. This cannot. We'll have to examine. Lordship will issue notice. We'll have to examine.
Issue without any any stay.
My lord.
Because at this stage, the case is fixed on 9th.
Hmm.
You appear before that court on 9th.
It's a bailable warrant.
No, my lord, so far, I'm not saying that, my lord, the appearance will be of any difficulty and all that. Bailable warrant issues has been issued, my lord can protect that. That is a different thing. But my lord, your lordship is examining the entire matter here. In that view of the matter, whether the proceeding can continue.
Hmm.
That is my submission, my lord. Bailable warrant or no bailable warrant, my lord, even if I appear, my lord, I'll not be put behind the bar.
Yes, heard Mr. K. Agarwala, learned senior counsel, assisted by Mr.
Cognizance.
What is your name?
Oh,
M. Das, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been preferred by the petitioner, Shri Diptendu Banerjee, impugning the continuance of proceeding of PR case number 1861/2023 pending in the court of Learned Chief Judicial Magistrate Kamrup Metro under section 5 of the Assam Protection of Interest of Depositors within bracket in financial establishment bracket close Act 2000, which was repealed by the Assam Protection of Interest of Depositors in Financial Establishment Repealing Act 2022. The petitioner has prayed for quashing of entire proceeding of PR case number 1861/2023. Stop. The facts relevant for consideration of the instant criminal petition, in brief, are as follows. That on 11/12/2020, 2014, one Shri Mrinal Sharma had, Inspector of Police, BI within bracket EO, Assam, Srimantapur, had lodged an FIR before the officer in charge of BI within bracket EO, Assam, Srimantapur, inter alia alleging that the Rahul Group of companies had entered into criminal conspiracy. The directors of Rahul Groups of company had entered into criminal conspiracy with one another and some other employees of the company and had launched several deposit schemes. That is fixed deposit schemes, recurring deposit scheme, MIS schemes. And widely published the same
Excise amendment
among the public by offering high rate of interest, alluring the public to invest their money in the said scheme. It was also alleged that the company did not obtain any certificate for the same from the Reserve Bank of India, and also no leave was obtained from SEBI. On receipt of the said FIR, next para, on receipt of the said FIR, BIEO PS case number 23/2014 was registered under section 120B/420/406 of the Indian Penal Code, read with section 5, section 4/5/6 of what is this TC?
Price cheats and money
Price
circulation
cheats and money circulation
schemes banning Act 1970.
scheme within bracket B,
In bracket banning Act.
Banning Act 1978. Stop. During the pendency of the investigation, the investigating officer had prayed for adding section 5 of the Assam Protection of Interest of Depositors Act, 2013, and the said prayer was allowed by the court by order dated 4/9/2019. Stop. Thereafter, on completion of investigation, chargesheet was laid on 27/11/2020, bearing chargesheet number 09/2020 against how many accused persons? 10 numbers of accused persons under section 120B/420/406 of the Indian Penal Code and section 4/5/6 of that price cheats and earlier act, as well as section 5 of the Assam Protection of Interests of Depositors within bracket in Financial Establishment Act 2000. So it is submitted by learned counsel for the petitioner that in column number 10 of the said charge sheet, where the particulars of accused persons against whom charge sheet has been laid, the name of the present petitioner was not mentioned, though the said name is reflected in column number 18, where charges are explained against the accused persons. Stop. It is also submitted by learned counsel for learned senior counsel for the petitioner that during the pendency of the said case, the which is the repeal act
Repealing Act.
at page
Page 85.
85.
No, before that. On receipt of the charge sheet, the learned session judge, Kamrup Metro, took cognizance against 10 numbers of accused persons who were named in column number 10 of the charge sheet. It is pertinent to mention herein that the against present petitioner, the cognizance was not taken by the session judge. Later on, the case which was registered on the basis of the charge sheet, that is sessions case number 4/2021, was transferred to the Court of Learned Additional Session Judge number 1. Who has also mentioned in order dated 7/1/21 regarding the names of the accused persons against whom charge sheet has been laid, and the name of the present petitioner was not mentioned therein. It is submitted by learned senior counsel for the petitioner that during the pendency of the sessions case number 4/2021, some of the accused persons whose names are mentioned in the column number 10 of the charge sheet approached this court and preferred a criminal revision, which has been registered as criminal revision petition number 240/2023, which was disposed of by 240/2023. Stop. The said criminal revision petition was disposed of by order dated 10/8/2023, whereby a coordinate bench of this court had on the ground that this whole act was repealed on the ground that Assam protection of interests of depositors within bracket in financial establishment bracket close Act 2000 was repealed by the Assam Protection of Interests of Depositor within bracket in financial establishment within bracket repealing Act 2022 has closed the proceedings of sessions case number 4/2021 and directed the transfer of the case in respect of the other offenses except section 5 of which act? Section 5 of the
Investors in Financial Establishment Act.
Assam Protection of Interest of Depositors in Financial Establishment Act 2000 had transferred the case to the Court of Learned Chief Judicial Magistrate, Kamrup Metro. Stop. It is submitted by learned counsel for the petitioner that though the name of the present petitioner does not figure in column 10 of the charge sheet where the names of charge sheeted accused persons has been shown. However, the Court of Learned Chief Judicial Magistrate, Kamrup Metro, by order dated 31/8/2023, passed in PR's case number 1861/2023, also issued summons to the present petitioners under section 5 of the under section 5 of the Assam Protection of Interest of Depositors, that Act, same Act, along with other provisions of Indian Penal Code, as well as the provisions of price cheats and MCS within bracket B Act. Learned senior counsel for the petitioner has submitted that thereafter, on 22/1/2024, the petitioner appeared before the learned session Chief Judicial Magistrate, Kamrup Metro, and as per the learned counsel for the petitioner, the next date was fixed on 2/4/2024, which is also reflected in the case details of the case against TRC case number 1861/2023, where the date has been shown as, next date has been shown as 2/4/2024. Due to the said due to this said fact, the petitioner could not appear before the Court of Learned Chief Judicial Magistrate and on 2/4/2024, on which date the Learned Chief Judicial Magistrate, Kamrup Metro, had issued bailable warrant of arrest against the present petitioner. Learned counsel for the petition, senior counsel for the petitioner, has submitted that in view of the order of the coordinate bench of this court in
Yes, to go.
criminal revision petition number 240/23 on 10/8/2023, and in view of the repealing of the act of the Assam Protection of Interest of Depositors within bracket in Financial Establishment Act by the repealing act of 2022. The cognizance under section 5 of the said act would not have been taken by the learned Chief Judicial Magistrate. Stop. Now, whether records would be necessary,
It's purely a law point.
law point.
That cognizance order is, of course, when we see the cognizance order, what I find is he has mentioned that case diary has been filed under this section. And the next line, of course, he writes that cognizance is taken under the sections of law, not aforesaid also. I mean, he could have clarified by writing the sections there.
We can drop that section now.
Yes.
Matter will be solved. Because ultimately this is going to happen.
Hmm.
It appears by by taking cognizance under section 5, whether entire proceeding will go.
No, not on that.
No.
My submission is not on that. My submission is that I have challenged to the entire proceeding also.
But
In view
your
of the
ground
provisions
is,
yes, sir. In view of the provisions of 1978, that act, my lord, section 4(5).
19,
That price sheet and, my lord, miscellaneous. Price sheet.
but
and-
your ground is that
No, not, this is one ground, my lord.
on another ground?
Another ground is, my lord, that it does not, my lord, even if taken the entire materials, whatever is stated in the FIR, whatever is stated in the, taken into consideration also, my lord, it will not come within the purview of, my lord, the Act 1978.
But then the deposits were made and he did not return.
No, that is
So
not, my lord, that's what I am saying, my lord, that this matter needs to be examined, my lord.
then in that case, records will be
Report
necessary.
will be required, man.
Learned senior counsel has, apart from the above ground, has also challenged the taking of cognizance of offense under section 4, 5, and 6 of price cheats and what is this MCS? Full form?
Right, cheats and money circulation scheme.
Money Circulation Scheme Banning Act,
Packet banning, packet close Act 1978.
1978. Stop. Next para. Considering the submissions made by learned senior counsel for the petitioner, the perusal of the records of PS case number 1861/2023 would be necessary for considering the instant criminal petition. Hence, issue notice to the opposite parties. Who are the opposite
Only
parties?
this,
Only state.
if state is there, both state can.
Oh, I can accept notice on behalf of R2 as well.
And call for the records of PRC case number
1861.
1861/2023
3.
from the Court of Learned
Chief Judicial
Chief
Magistrate,
Judicial Magistrate,
Kamrup Metro.
Kamrup Metro. As learned additional public prosecutor has appeared for both the opposite parties, no formal notice need to be issued
Yeah.
to the opposite parties. Stop. As apparently it appears that cognizance of offense under section 5 of the Assam protection of interest of depositors within bracket in financial establishment bracket place act 2000 has been taken, which has been repealed. The further proceeding of PRC case number 1861/2023 is hereby kept in abeyance until further orders. Let this case be listed after 4 weeks.
Given direction to recall the, my lord, available one.
No, it is state.
State then it's.
Petitioner appeared through.
My lord, your lordship is, my lord, petitioner appeared through counsel, my lord. He has not personally appeared. 22nd, my lord, January.
Earlier, there is a
That may be, my lord.
somewhere I have mentioned that on
22nd of January.
Second of January.
Just to call you.
On 22/1/2024.
22/1/2024. 22/1/2024, the petitioner had shown his cause for not appearing before the court through his engaged counsel. Let this matter be listed.
Maybe the lordship. 430 application lordship. FAR is at page 13 lordship. There is vulnerable lordship. And page 8 is the transaction. My lord, page next one. May read the vulnerable lordships.
Yes.
Page 13. সন্মানপূৰ্বক নিবেদন এই যে যোৱা ইংৰাজী 14/3/2024 তাৰিখে মোৰ দেউতাৰ বিল্ডিং ঘৰত ভাড়াতীয়াৰ গুদামৰ পৰা চিমেণ্ট চুৰি হোৱাৰ সংক্ৰান্তক লৈ মোৰ ভাইটি সিজুৰুল মুনিৰ ওপৰত পাটৰিয়াত আৰক্ষী চকীয়াতি গোচৰ ৰুজু কৰে। গোচৰ আপোচ মীমাংসা কৰাৰ পিছতো নিম্নলিখিত দালাল কেইজনে মিলি 50,000 টকা দাবী কৰে। তো টকাখিনি দিয়াৰ পিছত মোৰ ভাইটিক লকআপৰ পৰা উলিয়াই দিয়ে। This is the allegation against me, lordships. Actually, what happened in this case, lordship? Petitioner is the youth of the society, in that society, lordship. And the informant's brother has stolen some cement bags from an enterprise, lordships. Thereafter, the owner of the enterprise came to the petitioner, lordships, and informed him, lordships. Thereafter, this petitioner instructed the owner of the enterprise, lordships, to lodge an FIR. Thereafter, that FIR has been lost, and the informant's brother has been arrested by the police. And later on, what happened, my lord? Here, thereafter that matter was compromised, and the informant's brother has been released by the police, my lord. And as I instructed the owner of the enterprise, lordship, the informant became angry and filed this FIR, lordship, only to harass me, lordships. I am ready to appeal before the IU, lordships. Only some protection may be granted, lord. I am not the police officer, I have no any authority to release the person from the lockup, lordships. I am an educated youth in my society, lordships.
Of course, sir. He is one of the broker and he had demanded, it seems, 50,000.
Broker, what kind of broker? Between police and the public?
Between the informant and the accused. Informant and his brother. Informant and Hijrul Munir. Now, we don't have the earlier FIR here. Now, informant
No,
and
informant's brother
The
arrested,
allegation against him is that he demanded 50,000
lordships.
and that was paid also.
that
As
was
far as it
paid.
is paid, but I have not received, I have not demanded, lordships. And my lord, police, after compromising the matter, the police released the person's, lordships. I
Because
have
of
no
this
role to
payment.
play at that time, lordships.
You paid 50,000 to the informant paid 50,000 to you.
There is the allegation, lordships.
It seems so.
You and there are
Two more,
two more.
Rejek and Dadul.
My lord, who am I to release a person from the lockup, my lord? I am the youth of my society, lordships. It is done by the police, lordships. So, my lord, I am ready to cooperate in the investigation, lordships. Kindly come, some protection may be granted, lordships.
No, why are you apprehending your arrest?
My lord, my name is in the affair, lordship. That is why, lordships.
Only because
all.
of that fact.
Lord, our police also,
Police-
police also searching me, lordships. As this is the allegation against me, lordships.
Yes, Ms. Jahan.
It seems perhaps that amount is paid and after that it is compromised and then person got released. Of course, he is nobody to release him from the lockup.
Lordship.
But Mm,
In the earlier case, the brother on the informant was arrested, lordship. That informant is different, lordships.
that informant
Yes,
and
different. Just I instructed that earlier informant that to lodge an FIR against this against the brother of the informant, lordships. That is only my wrong, lordship, at that time, lordships. So, my lord, I am the youth, lordships. I have the name. I am the responsible person in my society. So I will cooperate in the action, lordship. Kindly protect me, lordship. And CD may be called for, lordships.
Now we'll peruse the CD first.
Well, some protection is granted, lordship. Because I'll see the affair, lordship. What I have committed, lordships. What wrong I have committed, lordships. Only I have, as per the law, only I have demanded some money and I release the person from the lockup, lordships. Who am I to release the person from the lockup, lordships?
Of course, the statement is, though the informant compromised the case. It seems that before that 50,000
Yes.
was paid. Though the informant compromised the case, but the broker had demanded 50,000
Yes.
and after paying the said amount, my younger brother had released from the lockup.
Yes.
Has been released.
I am not at all related to this case, lordships. It is the duty of the police to release the person from the lockup, lordships.
Heard Mr.
M. Hawk.
M. Hawk, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned litigation to the prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Azizul Haq, who is apprehending his arrest in connection with Sipaj RPS case number 34/2024 under section 420/387 of the Indian Penal Code. The accusation against the present petitioner is that on 16/3/2024, one Monazir Alam had lodged an FIR before the officer in charge of Sipazar police station, inter alia, alleging that on 14/3/2024, one case was registered against the younger brother of the petitioner, younger brother of the informant, wherein allegation was made that he had stolen some cement bags from the rented godown of the building belonging to the father of the informant. Later on, the said matter was compromised. However, it is alleged that even the matter was compromised, the present petitioner and two others demanded 50,000 from the informant, and only after payment of the 50,000 rupees by the informant, the younger brother was released from the lockup. Learned counsel for the petitioner has submitted that the petitioner is not a member of any police force, and the brother of the informant was apprehended by the police of Patharighat police outpost, and therefore the allegations made in the FIR is not believable. It is also submitted that the allegations made in the FIR are not true. Further, learned counsel for the petitioner has also submitted that though the petitioner is willing to cooperate in the investigation, police is searching him, for which an apprehension of his getting arrested in this case has arisen. Whether CD would be required?
Lordship, yes, we'll see.
Stop. Perusal of the case diary would be necessary. However, considering the fact that the younger brother of the first informant was not in the custody of the present petitioners, but was detained by the police of Patharighat police outpost only. The submissions made by learned counsel for the petitioner appears to be reasonable. Hence, during arrival, Hence, the petitioner is hereby directed to appear before the officer in charge of, hereby directed to appear before the investigating officer of Sipazhar Police Station case number 34/2024 within a period of 10 days from the date of this order and cooperate in investigation. So if he does so within the stipulated period of time, comma, in the event of his arrest in connection with Sipazhar PS case number 34/2024, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount subject to following conditions, condition number 1 and 2. Let this case be listed again on
Sometime in May, 6th of May.
6th of May.
And deep level.
Mayor, please, your lordship. This is an application under section 438 for a case registered in Juria PS, a white case number 43 of 2021, your lordship, and registered under section 120B, 420 and 406, dated 17/6/2021, your lordship. I am a 39-year-old woman. The
Woman.
Woman, your lordship. The FIR is on page number 10, your lordship. The allegation against me is that, your lordship, I, without the knowledge of few people, I created their account in PNB and then to withdrew all the money from their account, while they were not even having the knowledge of existence of their respective accounts, your lordship. I shall read the FIR, your lordship. The complaint is back to state that we are hailing from a very poor families, and just recent past we came to know that there are bank accounts in the name of each one of us at PNB CSP Singari, and by a conspiracy, accused number 1 has withdrawn. Accused number 1, Murshida Khatun, which is me, your lordship, has withdrawn money from our account. It is to be mentioned that in spite of bank CSP in our
What
village,
is your name, Murshida?
Murshida Khatun, I am not the bank employee, your lordship. I am nobody. I am a private person, your lordship. It is to be mentioned that in spite of bank CSP in our village, accused number 1 has taken us to PNB CSP Singari, but unfortunately, till the recent past, we were not aware about our bank accounts, as because of the accused number 2 has not given us our bank passbooks as well as the account numbers. Also not intimated us about the transaction details of our bank accounts, neither intimated us about the purpose of opening bank account. On the last March 2021, your lordship, accused number 1 came to our home at night time and one by one took our fingerprints and biometric device, telling us that it was for the affirmation whether money has been credited in our accounts. But she has no money. But she said no money has been credited in our accounts. Recently, we came to know that both the accused by a conspiracy made us to open accounts of PNB, CSP, Singori, and misappropriated the amount to whatever credited in our account from different heads. Now, your lordship, I want to draw your esteemed attention towards few facts, your lordship. First of all, the petitioner is a private person. She is actually a Sakhi Mitra, your lordship. No, Krishi Sakhi, your lordship. She has entrusted the role of Krishi Sakhi by Dalanghat Agriculture Development Block, where she conveys the message of the development program taken up by the government, for which she receives a very meager amount. Now, taking out a biometric device from a bank, like that of a Punjab National Bank, is a very big thing. Being a private person, I cannot do that, your lordship, which is simply impossible, your lordship. And if someone opens their account, how is that they do not know that they have a respective bank accounts, particular bank accounts in respective bank, or your lordship? Because for opening of each bank account, the photographs as well as the Aadhaar card and other identity proofs are required, your lordship. And if only there are, as it seems from the FIR itself, that they have never made any transactions. So how can there be any money in their respective accounts? And if only there is any money from their respective accounts, who am I to take out that money without their knowledge? Why will a bank like PNB will give me their money? without their knowledge, without any, without their signatures, nothing. Why will the PNB give me their money, your lordship? And as the accounts, and I want to emphasis on this, that if only they didn't know that they had some accounts that clearly inferences that they had never transacted any money, and that must be a zero account, zero balance account, or zero balance account in the PNB. Then how can there be any money for that I can steal from their account without their knowledge, without their signature, without being them in the PNB itself? Now, your lordship, I will also take you to. Now, why they are inframing me? Because your lordship, they think just because I am a Krisi Sakhi, they think I have hand in selecting the people who gets benefit from the government schemes. And because they didn't got this, they were not referred, or they were not benefited by certain government schemes, they framed me, your lordship. I have 3 growing up children, and my husband is bedridden, for which I have annexed a medical document, annexure number 2, your lordship. In on January 2022, 3rd January 2022, my husband had met with a very serious road accident, which made him incapable from the lower half of his body. So, because of that, I am the only earning member of my family, your lordship.
Yes.
At this time,
In fact, what the complainant has said that that the lady had taken them to the bank and has opened the accounts. Perhaps the documents were also taken by them for opening an account. And what money is there in the account? They said that whatever has been credited from different heads. So those were misappropriated by her by taking the fingerprints on the biometrics.
lordship may
course.
kindly see that at night accused number.
They don't know.
Lordship?
They even don't know about the existence of that.
They don't know about the existence, but they know
So,
that they were
money could
taken
have-
once.
Under some schemes,
Mm.
some money could have been deposited. That is the,
That is what
Every-
they think. Money could have come and she would have taken. Of course, everything is in a very,
Lordship, they have said one night.
let us call for the case study.
Lordship, meanwhile, I may be protected, your lordship.
Heard Miss P. Das,
Yes.
learned counsel for the petitioner. Also heard Miss S. Jahan, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Murshida Khatun, who is apprehending her arrest in connection with Juria PS case number 43/2021. The gist of accusation against the present petitioner is that on 19/6/2021, one Mazida Khatun and 14 others had filed an FIR before the officer of Jajori police station, inter alia, alleging that the informants had taken informants were taken to Punjab National Bank CSP Singari by the present petitioner and no, what she did
She's Sakhi, your lordship.
and opened bank account in the Punjab National Bank Singari branch. However, no intimation was given to the informant regarding opening of the bank account. It is also alleged in the FIR that on the last part, in the month of March
2021,
2020,
21, your lordship.
now this FIR is of 21.
Yes, your lordship. It's an old FIR, your lordship.
21.
Yes, your lordship. It is of June 21, your lordship.
And now you are being searched.
Yes, your lordship. All this while I was at home, there is no problem. There was no problem.
Where is the statement that police is searching you?
Lordship, now police is searching me because as they have every day come to my home in search of me, your lordship.
In the last part of March 2021, the petitioners came to the house of the
21, Bhavan, there is one more accused. Vijay.
It is fine.
house of the informants and took their fingerprint in biometric device, telling them that it was necessary for affirmation as to whether money has been credited in their accounts or not. It is also alleged in the FIR that the informant came to know that the accused persons named in the FIR, including the present petitioner, had misappropriated the misappropriated the money credited to the accounts of the informant from various heads. Stop. Learned counsel for the petitioner has submitted that the petitioner is a woman and is working as Rishi Sakhi at
First paragraph.
Lordship, she is entrusted to perform the role of Rishi Sakhi by Dalang Ghat Agriculture Development Block. Para number 2, your lordship.
by at Dalanghat Agricultural Development Block. And though the FIR has been lodged in the year 2021, however, police is now searching the present petitioner. It is also submitted by the learned counsel for the petitioner that as the petitioner is not an employee of PNB, Punjab National Bank. Therefore, the allegations made against her in the FIR that she had withdrawn the money from the account of the informants is not believable. Stop. Learned counsel for the petitioner has also submitted that the petitioner is mother of
3 children, your
3
lordship.
children and her husband is
Bedridden, your lordship.
presently bedridden after meeting with an accident. And she is ready to cooperate with the investigating officer. Hence, she may be given protection under section 438 of the Code of Criminal Procedure. On the other hand, learned additional public prosecutor submits that perusal of the case diary would be necessary for
And May
consideration.
6th of May.
Hence, call for the case diary, fixing 6th of May for case diary. However, in the meanwhile, considering the submissions made by learned counsel for the petitioner, as well as considering the fact that the submission made by the petitioner, above named petitioner is hereby directed to appear before the investigating officer of Juria PS case number 43/21 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If she does so within the stipulated period of time, comma, in the event of her arrest in connection with Juria PS case number 43/2021, she shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount subject to the satisfaction of the arresting authority with following conditions, number 1 and 2. Let this case be listed again on 6th of May.
If you like.
The dhaba of the petitioner along with some other dhabas, lordship, but could not find anything. But upon search in the house of the petitioner, the police had find 13 bottles of IMFL, lordship. Seizure list is at page 13, lordship. Page 13, annexer B, lordship.
Not annex D. Have you not preferred any bail application before coming to High Court?
No, not lordship.
Before
Hereafter-
magistrate courts,
Lordship.
before no court?
No, lordship. They have preferred here, lordship. So, 13, lordship.
Why you have not preferred?
Lordship, they contact us, lordship, to file a bail application here, lordship. So we have filed here.
No, when they had option of moving magistrate court under section 437.
Lordship. They have asked me to, they have approached here, lordship. They have asked us to file here, lordship. Only 13 bottles recovered, lordship, which were brought by the father of the petitioner, lordship, on 20th of March, lordship. Case memo is at page D, lordship. 10 days already behind the bar, lordship. 420 also not attracted here, lordship. And 406 is also not attracted, lordship. At best, lordship, 53(1)(a) may be attracted, lordship. Then also minimum punishment is 6 months, which may extend to 3 years, lordship. This one, did you- As per the Assam Excise Amendment Act 2018, lordship.
Oh, this is 53(1), Kotalan.
এই কথাই, মোৰ লগত আছে।
দিবাচোন।
But which may extend to 3 years.
So. You moved it before.
Yes, Ms. Jahan.
In
When-
fact, The
450 is there.
IMFL were, as he said that it was seized from his house, but the seizure list shows that below descriptive articles on being produced from the possession from Mahalakshmi Dhaba.
Lordship.
So it is seized from the dhaba, not from the home. 53(1)(a) is, of course, there is violation without any, so 53(a)(1), without, in contravention of the provision of this act, which was kept.
13 bottles, lordship.
13 bottles, yes.
Lordship. And case memo is also there, lordship. Of 20 March, lordship. 10 days already behind the bar, lordship.
But they have to have permission for selling the bottles, selling the liquor items. That they don't have.
No, we are calling for case day.
Lordship, 10 days already behind the bar, lordship.
No,
And
no,
most-
why have you not gone to the court which was nearer to you?
Lordship, 420 and 406 is also there, lordship. They have preferred to approach here, lordship. And regarding attraction of 420, lordship, recently Supreme Court has passed one judgment, lordship. Paragraph 10, lordship. And 11, lordship. It is clear,
420,
lordship.
it's okay, 420, when it
406
is,
and 420 will not come. If it at best come, lordship, this will come which punishment is 6 months up to 3 years, Lordship, already 10 days behind the bar. Lordship, they will cooperate, Lordship. If required, they will execute a bond also, Lordship, that they will, if they have done something like this, they will not do in future, Lordship. In the judgment, paragraphs 10 and 11 specifically depicts about section 420, Lordship. If required, they will sign a bond, Lordship. If something they have done, they will not do in future, Lordship, if required, Lordship.
No,
Only
no,
30
I'm not on that. I am on, though a person in custody can prefer an application under 439 directly.
439, Lordship will see the power of the High Court is there
It is there.
They are, Lordship.
directly to
Directly,
give
Lordship, they
bail.
are, they are, Lordship. So,
Lordship will see 439 of the CRPC. He has not moved it under 437.
the High Court has the power, Lordship.
A High Court or a court of session may direct that any person accused of an offence and in custody be released on bail. And if the offence is of the nature specified in 437, subsection 3 of 437 may impose any conditions.
So he can, Lordship.
Yes, what is your submission?
420, 406, I'm leaving aside, but 53, 1A violation is there. Of course, the punishment is 3 years. But without permission, without the permit, they have been selling those liquor items.
Okay, now make your submission.
I think,
Uh,
if required, they will execute a bond. I think seizure is
13 bottles, of course, 13 bottles of one bottle will not make any difference.
No, I am
But-
not inclined because otherwise the trend will start.
Directly
All
coming.
magistrate courts will be ignored. Though the power is there, this is a discretionary power. When to exercise it?
That I have to again go through. Whether bypassing 437, one can,
Lordship, directly they can come under 439, Lordship. Since 420 is also their, Lordship, they have approached his honorable court, Lordship.
Then you explain it to me,
Lordship.
whether you can bypass 437 or not.
Power is specific here, Lordship. Power is specific regarding 439, it is
No,
specific,
no.
Lordship.
On this ground that you can bypass 437 and come directly under 439. You show me some authority.
Regarding section itself is clear, Lordship. Since 420 is also there, 406 is also there, that's why they have approached,
437 is also there.
Lordship.
So what reasons compel you to ignore the court which was nearer to you at Nagaon and come
Probably,
direct?
Lordship, they have approached here, Lordship, because since they are not connected with any of the lawyers there, that is one of the reason, Lordship. That's, they know me, they have approached me that you file an application before the Honorable High Court, since 420, 406 and all these sections are there, Lordship.
No,
That
then
is the main reason, Lordship.
no, I need clarification on this point.
then we'll have to find some judgments.
You find out judgment.
Lordship,
When you are
regarding-
coming directly, you have to come prepared that such question may be posed.
Hmm.
Though I am also that the statutory provision is known to me that High Court has the power, but this power is discretionary. Without approaching 437, you have approached 439.
Lordship,
I
specifically
am
also
only
there.
putting queries that you can do so under such circumstances. You show me the authorities.
Tomorrow, Lordship.
Okay.
Alright, but there will be some judgments on this. Maybe under certain conditions you can come.
But offense are not such, Lordship. Regarding the offense, Lordship, it is also.
No, therefore, I am putting questions. If offense are such that you could have obtained relief before a magistrate court also very easily.
Lordship.
What compelled you to?
The basic reason is there, Lordship, and regarding the legal entity. Lordship,
You explain me about the powers of this court under 439.
then
That
to-
it can bypass 437 under these circumstances, or it may be a general rule also that anybody can come under 437, bypassing 437. I just want to know the law. You explain it to me.
then tomorrow, Lordship.
How Mr.
Keyboard, Lordship.
P. Bordal, learned counsel for the petitioner, who seeks some time to answer the query posed by this court regarding query posed by this court. Stop. The prayer is allowed. Let this matter be listed again on
Tomorrow, Lordship.
3rd of April.
Lordship,
Tomorrow, 3rd of April,
as motion, Lordship.
as a motion item.
Oblige, your Lordship.
I think. Wait here. Admission or not?
I'm for the 10 man. My lord. May it please the lordship. My lord, in this case, I'm behind the bar for 356 days, facing trial my lord, under section 20B to C. Lordship will find the FIR is page 13, my lord.
When were you arrested?
I was arrested on, my lord, 13/4/2023, my lord. And to my instructions, charges have not yet been framed. But in this case, I'm a driver of the auto, my lord, which carries passenger as well as sometimes, my lord, they deliver groceries also, my lord. And on the alleged day of occurrence, my lord, I was given by one Ali Hussain, my lord, rupees 350 to deliver some goods, some groceries, my lord, grocery items. So accordingly, my lord, the goods were loaded, and when the Naka checking was done, my lord, these contrabands were items were found. And because of that reason, my lord, I was arrested.
What was found?
It was, my lord, 191 kgs of ganja, my lord.
Okay.
And state facts also I disclosed, my lord, page 30 and 31, that is the interrogation chart, my lord. Right. (31) lordship will find. Right. During the interrogation, the accused person stated that on 12/4/23 at around 6 p.m., one person named Ali Amjad, aged about such and such village, Assam, hired his vehicle along with his auto rickshaw to transport narcotic drugs. Actually, my lord, it was stated to be the grocery items, my lord, to be delivered to the Putti village.
No, that is your submission, but it is the remarks shows that you knew that it was narcotic drug to be.
That is the interrogation chart shows that, my lord.
Now, what is your ground?
My ground is that although, my lord, I was carrying that, I was under the bona fide belief that these were the grocery items, my lord. And I did not have the knowledge, my lord. Otherwise, nobody would, my lord, indulge in such kind of for a 350 rupees, my lord.
No, now it is difficult to
Accept it.
believe you. Why should court believe you at this stage?
Lordship may either way decide, my lord,
Because apart from your denial, there is nothing.
no other absolute thing to,
Because during trial, you could have adduced evidence also.
yes, my lord.
But at the stage of bail, apart from your denial that you did not knew, there is nothing, and otherwise materials were seized from your possession.
Directly from the vehicle, my lord, that is driven by my,
My lord, the case is still in the appearance stage, Lordship. There were 4 accused persons, my lord. 3 were chargesheeted, Lordship, and 1 is absconder, Lordship. Now the case is fixed for appearance of the absconder accused person.
Otherwise, it is charged. Materials are against them.
The materials are against him.
There
Lordship.
are on what ground you will jump over the embargo of 37.
37, my lord. My only limited submission is that, my lord, although the goods,
You were not knowing.
my lord,
You were not knowing what.
that
But-
is the specific submission, my lord, I have at this stage. I was carrying that goods, carrying that narcotic, my lord, under the bona fide belief that these were the, my lord, grocery items, as told by the owner, my lord.
At this stage, Lordship, I am opposing you, my lord.
No, it is difficult.
The commercial quantity and my lord, case is still in the appearance stage.
Anything else?
No, my lord.
Then heard, Mr.
My lord, my colleague's name, A. Ahmed Devi.
Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. R. J. Barwa, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Ruel Uddin alias Jakir Uddin alias Jahir Uddin, who has been detained behind the bars since 13/4/2023 in connection with special NDPS case number 35/2023. The accusation against the present petitioner is that on, where is the FIR?
My lord,
FIR
FIR is at page 13, my lord.
that on 12/4/2023, one Ashish Mohanto, SI of Police of Kothaltoli Watch Post, lodged an FIR before the officer in charge of Bajari Sera Police Station, inter alia, alleging that on receipt of an information through through reliable sources, one Naka checking was conducted near Purti Bridge on National Highway number 208A. And during the Naka checking, one Bajaj auto rickshaw bearing registration number AS01AC 8213 was intercepted. And during search of the said vehicle, 41 packets of suspected ganja wrapped in plastic papers were recovered. On weighing the recovered ganja, it was found that the weight of the same was found to be 191.005 kgs. The learned counsel for the petitioner has submitted that the petitioner is the driver of the auto rickshaw from which the contraband was seized, and he was hired by one Muhammad
Ali-
Ayub,
Ali Ahmed.
by one Ali Amzal to transport some goods from Purti to Chandichira, and he was not knowing that the goods which were transported in his way auto rickshaw the where the contraband, where ganja. Stop. It is submitted by learned counsel for the petitioner that the petitioner was ignorant, as the petitioner was ignorant about the goods being carried by him, he cannot be held. It cannot be treated that he was in conscious possession of the seized contraband. On the other hand, learned additional public prosecutor, Mr. R.J. Borwa, has opposed the grant of bail to the present petitioner on the ground that the quantity of contraband seized in this case is of commercial quantity, and therefore the embargo of section 37 of the NDPS Act 1985 is applicable to this case. And there are materials to show that the seized, that the ganja which has been recovered in this case was seized from the possession of from the vehicle which was driven by the present petitioner. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the NDPS case, including the case record of NDPS case number 35/2023. It appears from record that the charge sheet, that after investigation, the charge sheet has been laid against the present petitioner along with 3 other co-accused persons. There are total 4.
4 man.
3 other co-accused persons under section 20B2C/25/29 of the NDPS Act, 1985. And the case is still pending at the investigation stage. So it also appears that apart from the mere denial by the present petitioner that he was not in conscious possession of the seized ganja, there is nothing to show on record. There is nothing to substantiate his submission to this effect. As there are materials, as there are implicating materials in the case records at this stage of trial against the present petitioner, and as the present case involves contraband of commercial quantity, the embargo of section 37 of the NDPS Act, 1987 is applicable to this case. And this court is of considered opinion that the petitioner has not been able to overcome the said embargo. Hence, the prayer for bail of the petitioner is rejected.
Okay. This is another matter, but this is the special NDPS case number 28 of 2023, my lord. In this case, I'll take your lordship to page 13 of my petition, my lord, which is the FIR, my lord. What happened, my lord, in this case, that an information was received at 6 p.m. that some lordship has got page 13, my lord.
Yes.
Yes, I'll just briefly page the facts of the FIR, my lord. What happened? But in this case, the information was that they received an information at 6 p.m. that some drug dealing is going to take place at one of the place, my lord. Accordingly, authorization was given, my lord. And thereafter, my lord, at 6:30, I'll take your lordship to paragraph 1, 2, 3, 4, my lord. I along with the police. Lordship has got it, my lord.
Yes.
Yes. I along with the police party used the departmental car registration number 7N, which was driven by ABC Sudhanshu Datta of Karimganj PS, proceeded from PS at 6:20 PM. So, my lord, they proceeded to the place
No,
from
no,
the
where,
PS at
where are you reading at page 13?
page 13, my lord.
Para?
Para 1, 2, 3, 4, my lord. That name of 4 police persons there after that paragraph, my lord.
Ah, yes.
So, my lord, at 6 PM, they received an information, my lord. Information, and accordingly, authorization was given to the informant to conduct search and seizure, my lord, and they left the place at 6:20 PM. And thereafter, my lord, there about 11:15, as per the seizure list, seizure was done at 11:15 PM. So my case is that, my lord, in this case, there is flagrant violation of the provisions of 42, my lord.
How?
Because, my lord, the proviso says that when you have a
After sunset.
yes, my lord, that proviso, my lord, I'm specifically pointing, my lord, provided that if such officer has reason to believe that a search warrant or authorization cannot be obtained without affording opportunity for the concealment of evidence or facility for the escape of the offender, he may enter and search the building. So here in my case, pilot, it is very apparent that at 11:15 search and seizure was conducted, pilot, without there being
Where
any
is the seizure list?
seizure list. Lordship will find at page 15, my lord. And lordship, seizure list I have not annexed, my lord.
Page 15 is the forwarding.
Forwarding, my lord, forwarding.
Now, at what time seizure was, search was conducted, how will we know?
Yes, my lord, after complete page 14, my lord. Page 14, my lord, second paragraph from the top. After completion of all these formalities, the police party departed from the PO at 8 PM and returned. So it is in between, my lord, 6:30 to 8 PM, my lord. Procedures as regards, my lord, arrest and seizure was done, my lord. So my humble submission is that without there being any, my lord, authority, the search and seizure in violation of 42 cannot be said to be a legal, my lord, search conducted under the NDPS Act, my lord, and which itself is a standalone ground for granting, my lord, considering the bail period of the petitioner.
Which condition they have violated?
My lord,
43, 42?
42 proviso part, my lord. Provided further.
Yes.
Okay, my lord, they can conduct the search and seizure after sunset, provided there are reasons, my lord, proper reasons, my lord, proper reasons are there for doing such search and seizure. But lordship will find from the records, my lord, I have not found any kind of, my lord, reasons also. Right, my lord, lordship is aware, my lord, Sarija Banu, we are denying 2004, my lord, which the Honorable Supreme Court has said that 42 is a ground,
Necessary.
my lord.
Which case?
2004 12 SCC 266, my lord.
2004,
12 SCC 266.
What it says?
It states that it was paragraph 7, Lordship, and handing over a copy of the paragraph 7. Paragraph 7 is relevant, Malik.
Okay. So violation of 42
Is a mandatory.
is a factor which has to be considered even during the consideration of bail
Bail
application. Yes, Mr. Barwa.
My lord. Lordship, may kindly say, my lord, section 42, Lordship. Section 42, the last paragraph, Lordship.
Which para?
Section 42A1, my lord, the last paragraph, my lord. Before 2, Lordship, section 42, 2, the last paragraph.
Provided.
Yes, provided that, further that if such officer is reason to believe that a search warrant or authorization cannot be obtained without affording opportunity for the concealment of evidence or facility for the escape of an offender, he may enter and search such building, conveyance or enclosed place at any time between sunset and sunrise after recording the grounds of this belief. But in this case, Lordship, they got the information at around 6 p.m. my lord, in the evening. So it was, my lord, necessary that if they make any further delay, Lordship, the accused may, my lord, they may abscond, Lordship, and they are unable to, my lord, search the house and, my lord,
No,
to
but
seize the, my lord,
grounds are to be
contraband.
recorded.
Grounds has to be recorded. My lord, this matter will have to be, my lord, also at the stage of trial, Lordship, because, my lord, whether this is, now it is in the stage of framing search, Lordship. Search is yet to frame, my lord.
No. The judgment which the counsel petitioner is showing,
My lord,
Sariza Banu,
my lord,
which says that even at the stage of consideration of bail,
my lord.
you have to show that 42 was complied with.
Yes,
So prima facie, it has to be shown that grounds were recorded and
My lord.
it was complied with. Otherwise, they may get benefit
my lord.
only
Now-
for the limited purpose of bail.
Yes. Now, Lordship may kindly see there, my lord. My lord, search sheet, Lordship.
When were you arrested?
I was arrested on 3/4/2023.
Yes, charge sheet. Where is the
My lord,
charge sheet?
search sheet, my lord.
Page
Lordship may
18, madam.
Start from 18,
Eight.
Lordship may peruse page 24, Lordship.
Page 24.
24, my lord, last paragraph, search,
Charge.
stage of investigation. On receiving information on 3/4/2023 of suspected drug trafficking, a JD entry was made by Karimganj PS GD entry number so and so, dated so and so. Then the OC Karimganj PS authorized SIP Nishiranjan Day to carry on the seizure issuing authority letter D2 by Karimganj PS GD entry number 74, dated 3/4/2023. After taking authority from OC Karimganj PS, the detailed staff along with the NDPS kit, weight machine and other relevant document left for PO by GD entry number so and so. On reaching the spot, the seizure officer SI Nishiranjan Day and staff called out some independent witnesses. Thereafter, a body search of the seizure officer was made by the independent witnesses in front of the suspected person in accordance with section 165 CRPC, reduced section 100 CRPC. After that, notice under section 50 served to both the accused person, namely Abdul Khalek D6 and Inamuddin D7. After that, a detained accused person was interrogated on spot and searched them. On interrogation, they told about the drugs which were kept at first side of the room of the house of Abdul Khalek.
from the said room Abdul Khalek, two big brown packets containing suspected Yaba tablets were recovered. The entire process of search was photographs and videograph. After that, the weight of the recovered drugs were done and seized accordingly by search and seizure list D8, and each of the brown packet numbered individually, that is Y1 to Y1 and Y2, and weight on the weight machine belong to Karimganj PS. And after all the seized drugs sealed inside the brown packet named as digestive with love by putting Karimganj PS seal and documents, polythene and mobile phone, and have been sealed in a small envelope containing signature of the accused, witnesses and seizing officer. A search and seizure memo D8 of both the suspected of the accused person, drugs, documents, mobile phone was made at the spot and signed by the independent witnesses, seizing officer as well as the suspect person. The entire process was videographed and individual picture pertaining to the collection of evidence were taken and printed out at the arrival of the PS after receiving certificate under section 65B of the Evidence Act. The seized drugs and other exhibits were also then taken to Thana and deposited in the Malkhana after making proper GD entry by Karimganj PS number so and so. And the Malkhana register D11 collected a Malkhana certificate from the registrar of the Thana. A rough sketch map of the PO was also drawn by the seizure officer with recording statements seizure witness. After receiving the FIR, the accused persons were interrogated by GD entry number so and so and issued arrest memo to both it. My lord. My lord, everything was done, my lord, in compliance with section 42 of the NDPS Act, lordship.
No, where is that reason? That
42.
reason for conducting
My lord.
search during night.
During night, my lord, that is the on receiving information, lordship. That is on 3/4/2000. That is clear from the FIR itself, lordship. My lord, FIR said this is to inform that information was received by Honorable SP Karimganj at about 6 p.m., my lord.
Yes.
At that, a large quantity of narcotic drugs are being concealed by two drugs peddlers in the house of Abdul Khalek. Accordingly, OC Karimganj PS made general diary entry number so and so, that is so and so. OC Karimganj PS authorized me to carry out the search operation, and accordingly, I obtained an authorization letter, my lord. So what else required, lord? So this is the compliance of section 42, my lord. Only, my lord, in terms of section 42 has not been mentioned, lordship.
42. Proviso puts specific requirement, condition, my lord.
Whether the copy of case diary is there.
My lord. My lord, this scan copy is there, my lord.
Okay. I'll go through it.
No, no, no. Deep reflect.
Heard Mr. M.A. Chaudhary, learned counsel for the petitioner. Also heard Mr. R.J. Barua, learned additional public prosecutor. Release this case for delivery of orders on the after tomorrow is on 4th,
Fourth, my lord.
4/4.
I'm deep.
काली जी फिक्स हुई से काली पैकेज फिक्स
Hello, it's a 439 application. Lord, I'll take your lordships to page 15, my lord, which is the FIR. The lordship got that.
page 15.
15, my lord, 15.
Yes.
I'll read from today. Today, that is on 9/9/2023. During conducting Naga checking duty at about 6:30 am, one 12-wheeler goods carrier truck. It's a goods carrier truck, my lord. Bearing registration number so and so, coming from Tripura side, was signaled to stop by UBC so and so of the Naka team. After stop, the truck parked in a safety place at the Naka checkpoint. Accordingly, the said truck was checked as per daily Naka checking duty. During conducting checking duty, it was suspected. You also can see the wording. It was suspected that there was a special secret chamber which may be loaded with narcotic items, that is ganja. Accordingly, the truck along with the driver of the truck, Pradeep Biswas. Then number 2 is Mintu Chaudhary. Number 3, Shujit Nath. My client is Shujit Nath, my lord, has shown to be an helper. Where cordon and information was immediately sent to my superior officers, also officer in charge, Bajari Chara, PS, about the matter by me over mobile phone. There was urgency. These are the important lines, my lord, your lordship can be got. There was urgency for conducting detention and search as the consignment of narcotic drugs was likely to be transported to some unknown places in no time. Hence, the authorization from a gazetted officer as per section 42 of the NDPS Act could not be obtained for conducting detention and search after sunset, as it was believed that such authorization could not have been obtained without affording opportunity for consignment of evidence, facility of escape of offenders, and removal and transportation of NDPS substances. Since there was a secret chamber present in the body of the truck, accordingly I approached to some local people for witnesses, and I, along with my staff, opened the secret chamber with the help of a screwdriver and spanner in presence of independent witnesses. Now, your lordship will find that ultimately the 400 kgs of ganja were seized. Now, the main question, my lord, where we are, my lord, harping on, the section 42 has been violated. My lord, in terms of section 52, my lord, I will take your lordship to that. The lordship kindly see section 42 of the Narcotic Act.
Yes.
Power of entry, search, seizure, and arrest without warrant or authorization. Any such officer being an officer superior in rank to a peon, Shipoi, or constable of the departments of Central Excise, Narcotics, Customs, then your lordship may skip this part. Police or any other personnel department of a state government, as is empowered in this behalf by general or special order of the state government, if he has reason to believe, this is important, my lord, if he has a reason to believe from personal knowledge or information given by any person and taken down in writing, these are, my lord, meticulously, these are, we will have to be, my lord, adhered to. Taken down in writing that any narcotic drug or psychotropic substance or controlled substance in respect of which an offense punishable under this act has been committed, or any document or any other article which may furnish evidence of the commission of such offense, or any illegality acquired property or any document or other article which may furnish evidence of holding any illegally acquired property which is liable for seizure or freezing or forfeiture under chapter so and so of this act is kept or concealed in any building, conveyance, or enclosed space made between sunrise and sunset. Enter into so and so, so and so. Then your lordship may see subclause 2, the last one. When an officer takes down any information in writing under subsection 1 or records grounds for his belief under the proviso thereto, he shall within 72 hours send a copy thereto to his immediate official of his superior. Now, your lordship will find the legislature has used the term reason to believe from his personal knowledge or information. Now, in order to, my lord, adhere to this, my lord, they will have to reduce down in writing, my lord, what sort of belief they had. Whether it's a personal belief or out of suspicion, here they have said that out of suspicion, my lord, they have inquired into and they found, my lord, the 400 bags of ganja. And then, my lord, regarding the authorized officer, gazetted officer, the permission to be taken, whether this has been reduced down in writing in an independent statement. It is not that it will be written down in GD entry and all that. In order to, my lord, persuade your lordship, I'll take your lordship to certain decision of the various high courts, including our high court and the Honorable Supreme Court also. Lord, I have, I'll take your lordship to those judgment one by one. These are all serially. Give it to me. The first judgment I am taking your lordships of a judgment of Calcutta High Court. My lord, how it should be, section 42 should be meticulously, my lord, adhered to by the prosecution. My lord, my learned friend will have to show from the case record that it was reduced down in an independent statement, unless they can show that, my lord, we are entitled to get not only bail, it's a case of acquittal. Now, my lord, I'll take your lordships to paragraph 4. The prosecution has alleged that a substantial quantity of yoga tablets was recovered from a truck. The petitioner, through learned counsel, takes the defense that the petitioner is neither the driver nor owner or a co-passenger of the truck and was alleged to have been found on the spot where the contraband substance was seized. The other point argued by counsel appearing for the petitioner is on the violation of section 42 of the NDPS Act 1985 and the standing instructions which was introduced for uniformity in the sampling process after seizure of narcotic substances. Under counsel appearing for the prosecution has argued that there is no violation either of section 42(1) or 2 of the Act, and that the standing order has also been complied with. Counsel relies on the case diary to show compliance of 42(2) and also that there has not been any delay in sending the samples before the judicial magistrate under section 52A of the NDPS Act. Then your lordship may skip the other paragraphs. I will take your lordships to paragraph 16. 1(6). Other subjects regarding, my lord, whether public vehicle or private vehicle, these are not disputed here. It's a private vehicle. Now, section 16 says, paragraph 16, my lord, section 42 of the NDPS Act relates to the power of entry, search, seizure, and arrest without warrant or authorization. Section 42(1) casts a mandate on the designated officer to record his reason to believe with reference to personal knowledge or information received and to take down in writing that any narcotic, drug, or psychotropic substance in respect of which an offense punishable under the Act has been committed is liable for seizure and is kept concealed in any building, conveyance, or enclosed place. The officer must record the reasons for such belief before entering and searching any such building, conveyance, or place. Now, that belief, my lord, he must record before entering into search and all that. Then paragraph 17, section 42(2) continues the statutory mandate on the officer who intends to enter and search such building, conveyance, or enclosed place between sunrise and sunset to intimate his immediate official superior the information recorded in writing and the grounds for his belief under section 42(1) within 72 hours. In the present case, the prosecution has submitted that the alleged secret information received by the prosecution was written down by a general diary entry by the special task force, which was subsequently intimated to the superior officer. The relevant documents are part of records. We are, however, of the view that a mere GD entry does not amount to due compliance of section 42(1). The Bombay High Court in Raju Bhal versus so-and-so held that an entry taken down in the station diary cannot be treated as information recorded under section 42(1) of the Act. The court relied on so-and-so, also a decision of the Bombay High Court, to hold that an entry in the station diary is not due compliance of section 42(1) of the NDPS Act. The second point which merits consideration is whether there has been due compliance of section 42(2) of the NDPS Act. The prosecution has relied on the case diary to show that there has been compliance of section 42(2) of the Act. The Supreme Court, however, in Mahavir Singh versus State of Haryana, reported in so-and-so held that the court is forbidden from using the entries of such diaries as evidence against the accused team. It was further held that if the court uses the entries in a case diary for contradicting a police officer, it can only be done in the manner provided under section 145 of the Evidence Act. That is, by giving the author of the statement an opportunity to explain the contradiction. The alleged compliance of section 42(2) being part of the case diary, therefore, falls short of statutory compliance. We also rely on Bhutta Singh Shukla to come to the conclusion that non-compliance of section 42 is not permissible in law. We are of the view that the report under section 42(1) must be in terms of a clear recorded statement in writing by the authorized officer under section 42(1) and must not be contained in a document which is closed from public view. Our view is strengthened by the fact that the NDPS Act is a special legislation entailing several statutory restrictions against the grant of relief. As the obligation cast on the officers must strictly be construed, there are also the rights available to an accused under the Act, which must also be given their due weightage. Since we have already formed an opinion on the non-compliance of the mandate of section 42(1) and 2 of the Act, the import of the standing order is not relevant. We, however, note that there are several decisions of the desired compliance of the standing order by several high courts, including so-and-so. The above reasons are sufficient to rebut the statutory restrictions under section 37 of the NDPS Act. The prayer for bail is hence allowed. Now, this is from the Calcutta High Court, my lord. And the next is, my lord, I am relying your lordship judgment. That is Alam Ali versus State of Assam. I'll be reading, my lord, from paragraph 7 onwards. Will you learn counsel for has the lordship got, my lord? Paragraph 7. It's by Mr. Alam Ali versus State of Assam.
Yes.
I'm reading from paragraph 7 onwards. The learned counsel for the petition has submitted that the prosecution side has not complied with mandatory provisions contained in section 42 of the NDPS Act 1985. And on that ground alone, the petitioner is entitled to get bail in this case. By referring to the seizure memo dated 26/12/2022, by which the contraband in this case was seized, the learned counsel for the petitioner has submitted that it is apparent that seizure has been made at 9 p.m., that is after sunset. However, no authorization is there to conduct search and seizure in the rented flat of the petitioner after sunset. Learned counsel for the petitioner has further submitted that the officer conducting the search and seizure in the rented flat of the petitioner after sunset has not recorded any grounds of his belief as to what necessitated the search of the house of the petitioner after sunset. Hence, there is total violation of the mandatory provision contained in second provision to the section 42(1). And the counsel for the petitioner in support of his submission has cited a ruling of Supreme Court, that is State of Rajasthan. My lord, I think it's time to rise.
Okay.
I'll continue at 2 p.m.
Yes, Your Lordship.
This is a judgment of Alam Ali versus State of Assam.
Yes.
I read paragraph 7. Now I'll take your lordships to paragraph 10, my lord.
Yes.
Learned counsel for the petitioner, relying on the decision of the Supreme Court of India in the case of Bota Singh versus State of Haryana, has submitted that the non-compliance with the requirement of Section 42 of the NDPS Act is impermissible, whereas delayed compliance with satisfactory explanation will be acceptable. Compliance of Section 42, however, in the instant case, there is not even the delayed compliance with the requirement of recording the grounds of belief, which necessitated the search of the house of the petitioner after sunset, hence there is total violation of the mandatory provisions. Learned counsel for the petitioner has also submitted that while considering an application for bail in a case where commercial quantity of contraband is involved, the question as to whether mandatory provisions of the NDPS Act were followed by the prosecution side or not becomes relevant. Any non-compliance of the mandatory provision would entitle the accused to be released on bail in spite of the embargo of Section 37 of the NDPS Act. Learned counsel for the petitioner has cited a ruling of the apex court in case of Sharija versus State 2004-12 SCC. The lordship has stated that. Then your lordship may skip the other paragraphs. Your lordship may come down to paragraph 18, maybe 180.
Yes.
It also appears from the order dated so and so passed by the learned special judge in NDPS case number so and so that the authorization letter stated in GD entry number so and so dated so and so has never been submitted by the investigating officer in the court. Thus, in the instant case, it appears that the prosecution is not been able to show that there was any authorization to conduct search in the rented premises of the present petitioner on 26/12 after sunset. There is no record to show that the officer who conducted the search after sunset in the rented premises of the petitioner had recorded the grounds of belief. This is very important, my lord. Your lordship has very categorically stated that in terms of Section 42, had recorded the grounds of his belief that necessitated the search of the rented premises of the petitioner after the sunset. Therefore, it appears that the mandatory provision contained in second provision to the Section 42(1) of the NDPS Act were not followed in the instant case. Then paragraph 20. As observed by the Supreme Court of India in Sharija Banu versus so and so, the compliance of Section 42 is mandatory and is also a relevant fact, which would engage the attention of court while considering a bail application. In the instant case, it appears that there has been non-compliance with the mandatory provision of Section 42, and hence, prima facie, the search and seizure in this case, which is in contravention of the mandatory provision of Section 42, makes the said search and seizure and recovery made during said search and seizure of the contraband doubtful. Under such circumstances, for the limited purpose of consideration of the instant bail provision, it can be held that there are reasonable grounds for believing that the present petitioner is not guilty of the offence for which he has been charged in this case. Now, your lordship may skip this. Now, the next decision I'll be citing of the decision of this honorable court reported in 2022 4 GLT, page 422. Hello, this is Larik Ram. I'm taking to your lordship one short paragraph, that is paragraph 8, showing that, my lord, in that case also, Section 50 violation was there. And the driver of the truck who was driving, he was not in know of the thing because the consignment was given to him to reach to a destination. My lord, in this case, my lord, it is held by the prosecution that I am a helper. If I am a helper, in that case, I'll know that what sort of consignment it is there. In that context, my lord, I am taking it to your lordship. Your lordship, kindly see the paragraph 8. Perusal of the case diary, it is revealed that 10 cartons containing 3,000 bottles of Fancial cough syrup were recovered and seized from the truck bearing number so and so, driven by the accused petitioner. The FSL report shows that sample of Fancial cough syrup gave positive test for codeine present as so and so and contained 186.5 ml per bottle. It further transpires that the accused petitioner is the driver of truck of VRL Logistics and is the duty to deliver the consignments of various goods loaded by the said company to the consignee as per Chalan. After thorough investigation, the investigating officer in his note dated so and so noted that the seized cartoons bore seal and pack of VRL Logistics Company and loaded for transportation by the company truck driven by the accused petitioner for delivery. It has been further noted that narcotic suppliers peddlers misuse the vehicles of VRL Logistics to fulfill their malicious intent, which were just carried by the accused driver. This finding of the investigating officer is of course subject to final outcome of investigation. Therefore, this court is prima facie of the opinion the rigors of section 37 of the NDPS Act are not attracted in the peculiar backdrop facts and circumstances concerning the present accused petition. Next decision which I'll be relying, that is the Bombay High Court. I'll be relying on paragraph 5, 6, 7, 8, 11, and 12. Well, I'll take first to paragraph 5, a short paragraph. Lordship got it.
Yes.
Section 42(1) of NDPS Act requires the person receiving the information to record it into writing, exactly in our case. Section 42(2) of NDPS Act mandates that such information received by the police station has to be forwarded to the immediate superior of the officer receiving the information within 72 hours. In the case at hand, the police inspector is the officer who had received the information. Therefore, it was obligatory on his part to record the information as mandated by section 42(1) of the NDPS Act and send it to his immediate official superior within a period of 42 hours from the date of its receipt. So far as recording of information as required under section 42(1) is concerned, admittedly the said information was not recorded. It was tried to be argued that entry was taken in station diary, and the same is sought to be treated as the information recorded under section 42(1) of the NDPS Act. Under counsel, so and so place reliance on this case of Rajwan Kadu versus Maharashtra decided by this court. In the case of Rajan Kadu cited, this very question had fallen for consideration before this court. It has been held as far as non-compliance with section 42 of the Act is concerned, it can be seen that the information was received by police NAC so and so. The FR does not indicate that he had reduced the information into writing or provided any copy of the information to his superior officer. The statement of API Divekar also does not indicate that he had reduced the information to writing or forwarded the same to his superior officer. However, the prosecution is relying upon the entries made by senior PI Stable of Upshanagar Station Diary to show that the compliance of section 42, that cannot be considered to be the compliance of section 42 of NDPS Act. The point which is canvassed by under counsel for applicants is that the person who had received the information had not forwarded to the superior officer, and there is nothing on record to indicate that any such information was forwarded in writing. It is therefore rightly contended that there is non-compliance of section 42(2). This observation of this court clearly indicate that entry in station diary is not a compliance under section 42 of the NDPS Act. Next, which para? 11. Now, your lordship may see paragraph 11B, my lord. 11B, small b.
Yes.
But if the information were received when the officer was, your lordship got it.
Yes.
But if the information was received when the officer was not in the police station, but while he was not on the move, either on patrol duty or otherwise, either by mobile phone or other means, and the information calls for immediate action, and any delay would have resulted in the goods or evidence being removed or destroyed, it would not be feasible or practical to take down in writing the information given to him. In such a situation, he could take action as per clauses A to D of section 42(1), and thereafter, as soon as it is practical, record the information in writing and forthwith inform the same to the official superior. Then, my lord, your lordship may come to paragraph 12. In the case at hand, there is not even a delayed compliance. Simply a letter is forwarded to the official superior about the information received. In this view of the matter, since there is no compliance of section 41(1), 42(1), and 42(2), there is no possibility of conviction of the accused, as held in the case of Sarija Banu, so-and-so versus State, for Inspector of Police. The question of compliance can be considered at the stage of consideration of application for bail. In this view of the matter, the applicants are entitled to be released on bail. Next decision is from Kerala. I'll just rely on paragraph 9 and 10. This one relating to what? My lord, the paragraph 9 I am relying on to show that there was a procedural irregularity. And if it occurs that way, my lord, it violates section 42. Para 9, my lord. No, para 10. No? 9 and 10, my lord. I'm reading 9. It is
Here
true that the
section 50 is involved.
yes, yes.
But in our case, in the instant case, 50 is not involved.
So 50 is not there, but I'm showing just to show that if there is a violation in, my lord, checking the person, my lord, if there is a violation of section 50, it quickly, my lord, it is at par like section 42 also. In that context, my lord, is a question of search and seizure. Therefore, it also helps our case. If that violation remains, my lord, it's a substantial violation, and the paragraph 10 will be more important, my lord. This is only at the stage of investigation, and court is considering their application for bail. Now, the question is whether this court should consider and go to such an extent. I have no doubt that if the very search and seizure are bad and vitiated, that would cut the very root of the prosecution case, and therefore such an aspect can be considered at that stage. Therefore, without going into the other aspects of the matter, the petitioners can be released on bail. Then 2004, your lordship dealt so many times, but still then, my lord, I would like to rely on paragraph 7 of 2004, 12 SCC 266. And the question here is, my lord, whether at the time of consideration of the bail application, whether your lordship will go into that. That was a Pesco said, and your lordship also held in that manner. It is pertinent to note that in the bail application of the appellants, it was alleged that there was serious violation of section 42 of the NDPS Act. In the impugn order, nothing is stated about the alleged violation of section 42. And it is observed that it was not necessary to consider such violation at that stage. The compliance with section 42 is mandatory, and that is a relevant fact which should have engaged the attention of the court while considering the bail application. Now, the last decision I'm bothering your lordships. This is 2011 SCC, page 130. I'll rely on paragraph 9, 10, and 12. Paragraph 9, my lord. The reading of the above said provision presupposes that if an authorized officer has reason to believe from personal knowledge or information received by him that some person is dealing in a narcotic drug or a psychotropic substance, he should ordinarily take down the information in writing, except in cases of urgency which are set out in the section itself. Section 42(2), however, which calls for interpretation in the matter before us, is however categorical that the information, if taken down in writing, shall be sent to the superior officer forthwith. In Karnal Singh versus so and so, this court has held the provision of section 42(2) are mandatory and the essence of the provision has been set out in the following terms. In conclusion, what is to be noticed is that Abdul Rashid did not require lateral compliance with the requirement of section 42(1), 42(2), nor did Sajan Abraham hold that the requirements of section so and so need not be fulfilled at all. The effect of the two decisions was as follows. The officer on receiving the information of the nature referred to in subsection 1 of section 42 from any person had to record it in writing in the register concerned and forthwith send a copy to his immediate official superior before proceeding to take action in terms of clauses so and so. But if the information was received when the officer was not in the police station, but while he was on the move, either on patrol duty or otherwise, either by mobile phone or other means, and the information calls for immediate action, and any delay would have resulted in the goods or evidence being removed or destroyed, it would not be feasible or practical to take down in writing the information given to him. In such a situation, he could take action as per clauses 82 of section 42, and thereafter, as soon as it is practical, record the information in writing, forthwith inform the same to the official superior. In other words, the compliance with the requirements of section 42(1) and 42(2) in regard to writing them, this is, my lord, very crucial. In regard to writing down the information received and sending a copy thereof to the superior officer should normally precede the entry, search, and seizure by the officer. But in special circumstances involving emergent situation, the recording the information in writing and sending a copy thereof to the official superior may get postponed by a reasonable period, that is after the search, entry, and seizure. The question is one of urgency and expediency. While total non-compliance with requirements of subsection 1 and 2 of the section 42 is impermissible, delayed compliance with satisfactory, my lord, word is used, satisfactory explanation about compliance with section 42. No, there is illustration, your lordship may skip that. Now, paragraph 12, my lord. Mr. Dalal, the learned counsel for the respondent state, has however referred to para 34 of the judgment of the Constitution Bench in Karnal Singh versus so and so, with respect to the latest electronic technology and the possibility that the said provisions may not be entirely applicable in such a situation. Consideredly, the present case does not fall in that category. In any case, the principles settled by the Constitution Bench are in para 35 and have already been reproduced by us here in above. Likewise, the dispatch of a wireless, I'm on that line, my lord. Likewise, the dispatch of a wireless message to PW6 does not amount to compliance with section 42(2) of the Act as held by this court in state. Now, my lord, about dispatch through wireless message, I am taking to your lordship the FIR once again, my lord. Now, what if my learned friend can satisfy your lordship that the investigating officer has recorded the person who has the belief that all sorts of compliance was meticulously followed, my lord, he must reduce it in writing in an independent paper which will have a, my lord, public view. Now, unless he can, my lord, satisfy your lordship that those things are meticulously adhered to, my lord, my client is entitled to get bail. And here your lordship kindly see the last line I'm taking your lordship's FIR last line, where cordoned and information was immediately sent to my superior officers in about the matter by me over mobile phone. Now, whether this is a sufficient compliance in view of the PESCO decision. Now, my lord, at this stage, I wind up my submission subject to what my learned friend can satisfy your lordships, whether there is on record, my lord, there is a meticulous adherence of the section 42. If you can satisfy, he will have, if he cannot satisfy, my lord, it's a case of, my lord, acquittal, and in case of acquittal, as the lordship aware, the rigor of 37 will evaporate. And therefore, it's a case of bail, my lord. Let my learned friend satisfy lordship.
My lord, what about the, my lord, apex court decisions, my lord, as well as the other high court decisions cited by my learned senior colleague, lordship? These are all related to, lordship, the offense wherein the prior information was obtained by the police, lordship. In this case, there was no prior information. It was just a nakaseki. So for this, lordship, may I read the FIR first, lordship? S phase 50. My lord, I am not reading the, my lord, entire FIR, my lord. My lord, the second paragraph. Today, that is on 9/9/2023, during conducting nakaseki. Nakaseki is what, lordship? Some police person, lordship, they, my lord, stay in the, my lord, in the middle of the road, lordship, and they stop the vehicle and they check the vehicle, ask for the, my lord, identity of the driver, then ask what the vehicle has carrying, my lord. These are the nakaseki, lordship. Conducting nakaseki duty at about 6:30 a.m. One 12-wheeler goods carrier truck bearing registration number so and so coming from Tripura side was signaled to stop by UBC Dhrubajyoti Tamuli of the Naka team. After stop, the said truck parked in a safety place at Naka's checkpoint on NS08. According to the said truck, said was checked as per daily Naka checking duty. Now, my lord, during conducting the Naka checking, 3 persons were found. One is my lord Pradeep Biswas, he was the driver. Secondly, lordship, one Mintu Chaudhary, he is the co-driver, lordship. And thirdly, this accused petitioner, Sujit Nath, he is the helper come handyman. Now, my lord, next page 16, my lord. There was urgency for conducting detention and search as the consignment of the narcotic drugs was likely to be transported to some unknown place in no time. Hence, the authorization from a gazetted officer as per section 42 NDPS Act could not be obtained for conducting detention and search after sunset, as it was believed that such authorization could not have been obtained without affording opportunity for consignment of evidence, facility of escape of offenders, and removal of transportation of NDPS substance. Now, Lordship, they have recovered more than 400 kgs of ganja, 400 kg and 200 grams of ganja from the truck, Lordship, which was, my lord, concealed in a secret chamber of the truck, my lord. Now, Lordship may come to, my lord, page 18, Lordship. Page 18, Lordship, I am reading the, my lord, 1, 2, 3, 4, 5, 6, 7 paragraph, Lordship. It is to be noted that during checking, the helper of the said truck, namely Sujit Nath, tried to escape from PO. But in the quick action of the Naka party and also with the help of the local people, he was apprehended, and during the time, the driver was assaulted by public and he got minor injury. During preliminary investigation, the apprehended driver stated that one Sri Giribhai alias Bivas had mobile number so and so of Agartala, Tripura, to be the sender of the consignment, which was contacted with the driver had mobile number so and so. It noticed that the suspected sender Giribhai alias Bivas was also contacted with the helper of the vehicle, Sujit Nath, had mobile number so and so, with the same mobile number. Now, my lord, there was no prior information for which, my lord, section 42 is not attracted, my lord. In this case, it was a Naka checking, my lord. So, my lord, the police during the regular Naka checking, police stopped the truck, checked the vehicle, and found the contraband. So, my lord, the applicability of section 42 does not arise at all, lordship. In this regard, lordship, may I please one decision of the Honorable Apex Court, lordship. It is 2018 9 SCC, page 708, lordship. 2018 9 SCC, page 708, SK Raju versus State of West Bengal, lordship. My lord, in this, my lord, in this case, lordship, there was a chance recovered from the vehicle, and the Honorable Apex Court held that, my lord, requirement of section 42 and 43 does not require, lordship. Secondly, lordship, I also placed the decision of the 2009 8 SCC 539, that is Colonel Singh versus State of Haryana, lordship. 2009 8 SCC 539.
2009 8 SCC.
2009 8 SCC, page 539, lordship.
Colonel Singh.
Colonel Singh versus State of Haryana, lordship. In this case, lordship, my lord, though the, my lord, the writing down the information on the receipt of it should normally proceed and search seizure by the officer, my lord. In exceptional circumstances that warrant immediate expedient action, the information shall be written down later along with the reason for the delay, my lord. When the Colonel Singh has said, lordship, if there was, my lord, suppose there was positive time, lordship, they could not be informed, lordship, then, my lord, the information can be, my lord, written down after the search and seizure also, lordship. So whatever the decision relied on by my learned senior colleague.
Whether in this case later on it was written.
Later it was informed because it was a Naka checking, lordship. The track was stopped, it was said, the, my lord, contraband found, my lord. So where is the mandate of section 42 come, lordship? It is not required, lordship. It is clear by the Honorable Apex Court, lordship. So, lordship, at this time, lordship, I oppose this bail application, my lord, and my lord, charges is, my lord, yet to be, my lord, framed till date. So let the search frame, lordship, and he may place all the, my lord, all the material, lordship, at the time of framing of the search before the trial commencement. And my lord, as per the scan copy, lordship, case is fixed for the copies, lordship. After that, lordship, search will be framed.
Yes, anything?
Lord, I ask myself whether my learned friend has discharged his responsibility. If the record is there, let him show that 42 complaints is there or not. My lord, I'll read once again.
No.
Section 42, my
The
lord.
submission is that 42 is not applicable in this case as it was a chance recovery
My lord,
without prior information.
now the question is, my lord, if I can read it once again.
Yes, yes.
My lord, 42. Any such officer being an officer superior in rank to a peon, chief, all these things, my lord, I'm just skipping. The next page, your lordship will find. Police or any other departments of a state government as is empowered in his behalf by general or special order of the state government, if he has a reason to believe from personal knowledge. Now they are saying, they are suspecting that some materials may be there. Now, what he will have to do in that stage? My lord, the next stage is take down in writing.
No, but if he has reason to believe.
He has reason to believe.
But in this case, he had no reason to believe. He only suspected.
Even in that case, that suspicion will also have to be written down.
Whether on suspicion, this clause would be applicable.
Yes, my lord, because it is very explicit in nature. The language your lordship kindly see.
No, in this case, there is no suspicion
Let
also.
me say,
My lord.
given by any person and take down in writing under whatever the circumstances is.
No, under what circumstances he will take down it in writing?
Now, if he is saying that on suspicion, then that will have to be reduced into writing. Because otherwise this 42 will have no meaning. My lord, why the object of this section is, my lord? Because these sections, this entire legislation is very stringent. Now, if you were to go by these sections, my lord,
No, this, let me understand it.
my lord.
This 42 is applicable if the seizing officer has one reason to believe from personal knowledge or information given by any other person,
Exactly.
then he has to take it down in.
Yes.
In the instant case, the informant is saying that he just suspected that in secret chambers, ganja may be concealed.
Yes.
He never said that I had prior information, I had reason to believe.
No, my lord, I'm not going to prior information. I'm on the personal knowledge, means suspicion is also personal knowledge. Then why you are not writing it down? One should be fair, my lord, because the accused do not have any right. Now, only the provision which are there, that will have to be meticulously adhered to. Why you are not doing it? My lord, there are so many decisions. We are not satisfied because if the prosecution lapse is there, and if any criminal is acquitted, this, my lord, is not a very good thing. It's not a satisfactory thing at all.
Is it your submission that on mere suspicion, he cannot conduct a search?
He can. He can, but
Whether
then
on mere suspicion he can,
he can, but
or
in that,
whether he has to have reason to believe.
exactly, my
There
lord.
is a difference between suspicion and reasons to believe.
Reasons to believe, my lord,
Reasons
that
to
is his
believe is-
satisfaction. That
No,
is his
let
personal
me understand.
satisfaction. He'll
To
have to
my
reduce that.
understanding, reason to believe is on a higher pedestal. Reason to believe must have some basis on which he arrives at that, and suspicion may not have any basis.
My lord, but I feel personal knowledge, the suspicion comes within the ambit of personal knowledge. He was from where he's suspecting from some sort of, my lord,
For suspicion also some basis is required. That is your.
he has to, my lord.
Okay.
Because so far suspicion, the language is not that way very much specific here, but it comes within the ambit of personal knowledge. Because
When
that satisfaction,
when we use the phrase knowledge, that means there is some source. For knowledge, there has to be some source.
yes,
Whether such a source is required for suspicion also.
my lord, I believe since it is a stringent legislation, therefore, when it is very specifically written down, the legislature has used the reason to believe.
Yes.
This word is very specific, my lord. In all other the provisions, this wording is not there. Now, when you are going to see or arrest someone, your satisfaction must be reduced down in writing. And it is not that you will make some entry in the GD entry and all that, in the charge sheet or FIR, it is not that. It is an independent writing in so many decisions, even the apex court also say it. So therefore, I am requesting my learned friend, why you feel shy to please those things are complied with or not? Merely saying the 42 is not applicable. Will it, my lord, discharge their responsibilities?
Okay.
Let him show from the record what they have done.
In this case, otherwise 42 was not complied with.
No, madam, that is madam reflected from the madam FIR. Lordship may kindly see.
No,
Uh,
he has
Page
later on,
number 16, yes, Lordship.
after conducting the search and seizure,
After one, then it was
whether
informed.
he
Lordship.
informed his superior,
Superior officer, Lordship.
whether he had informed.
My lord, that is why there was an urgency for conducting detention and search as the consumption of narcotic drugs was likely to be transported to some unknown places in no time. Hence, the authorization from a gazetted officer as per section 42 NDPS could not be obtained for conducting detention and search after sunset, as it was believed that such authorization could not have been
And
obtained
Mr.
without.
Datta, one more query.
Yes.
The public prosecutor, additional public prosecutor has cited the ruling of S.K. Raju, where it is mentioned that if the recovery is a chance recovery, then 42 is not applicable.
My lord, the facts of this case, there is a marked striking difference between both the cases. My lord, that your lordship can keep it parted. So far that part is concerned, my lord, I'll make my argument because this is a striking difference. My lord. In that particular circumstances, the appeals court said that 42 compliance may not be necessary.
Okay, then you explain also the distinction between the phrase reason to believe and suspicion.
Suspicion.
Is
Yes.
there any distinction? Because here the FIR categorically states that on suspicion.
On the,
Now,
yes,
whether only on suspicion, search and seizure procedure can be initiated
yes,
unless he has reasons to believe.
my lord.
Am I clear in
Yes,
conveying
yes,
my?
my lord. I could get it.
The question is whether on mere suspicion, search and seizure can be initiated at all or not,
Yes.
or there has to be a reason to believe for initiating the
Right.
search and seizure procedure. Okay. Heard. Mr. S.K. Datta.
As the
S. Datta, learned senior counsel assisted by Mr. S. Datta, learned counsel for the petitioner. Also heard Mr. R.J. Borua, learned additional public prosecutor. The hearing remained inconclusive. Let this matter be listed again when
date. Friday. My lord, Friday.
this coming Friday.
On Fridays, 5th of April. As part of it.
Yes. Much obliged.
What's your fixed for it? Why it is fixed at 2?
My lord, CD was called for my lord in this item.
City receipt lodge.
No, what was the reason for the mentioning?
Petition has not been, there is no interim protection, my lord.
No,
No interim protection there, even.
but there are a lot of such cases where
My
interim protection.
It is a simple case, my lord. All sections are bailable, only one section is non-bailable, my lord, which is not attract, my lord, as per the plain reading of the FIR, my lord. Yes, 13 is the FIR, my lord. May I read, my lord?
No, I am asking because from now onwards, I have to be careful while
My lord.
you mentioned before the court for listing the matter at 2. There has to be some specific reasons for mentioning. Yes. Yes, proceed.
Page 13 is FIR, my lord. Right, FIR is the allegation that, my lord, there is in some transaction, some work was done by the present complainant, my lord, for the present petitioner, my lord, and there is an area amount of, my lord, 25,000, my lord, and for me, my lord, it is 10,000. For them, it is 25,000, my lord.
Okay.
During the payment of that, my lord, on the day of the 20th February, my lord, the incident
what-
occurred as per the FIR, my lord. There is some tussle between the petitioner, between the present petitioner and the informant, my lord, and this FIR has been lost. If lordship may go to the registered section of the FIR, my lord, FIR was registered under section 417, 352, 153A, 506, 34 IPC, my lord. Section 417 is bailable, my lord. 352 is bailable, my lord. Only non-bailable section is the, my lord, 153A, my lord. And why, my lord, 153A is attract, my lord? As per plain reading of the FIR, my lord, only one line is written, my lord, in the FIR, page 13, paragraph 2, last line, my lord. May I read, my lord?
Yes.
He had further told Raju, who is a non-Assamese person, that he will have to leave Assam if he tries to fight with Chandan. Chandan is the present petitioner, my lord, and the Raju is the one of the informant. This is the line, my lord. Only that line, my lord, a non-bailable section is been attracted in this section. Lordship also well aware about that, my lord. Section 153 is a controversial section, my lord. It is come when there is enmity between the two different groups, my lord, not two different person, my lord. Even a confined room, my lord. This is in a confined room in the office room of the informant of the petitioner, my lord. The incident was took place in the office of the present petitioner, my lord. In a confined room between two person, one person. If for the sake of argument, I said that line, my lord. Even then, my lord, 153 is not attract, my lord, as per the FIR, my lord. 153A, my lord. And it is a civil dispute, my lord. Only given a criminal color, my lord, this FIR has been lost, my lord.
Yes. Mr.
Lordship, CD received. In this connection, Lordship, police has recorded the statement of the employees of that particular person, that is the accused petitioner's office, where in the note it is found that there are two persons who are looking after the CCTV footage also, because the allegation in the FIR is that they have been instructed to delete the CCTV footage. From their statement also, Lordship, it is revealed that they were present there and the incident was there, and that person threatened him, also beat him. Force was given. So Lordship, may kindly see the CD, that part. And another witness from the in the nearby area also they have also stated in the same line.
If my lord, if the considering the face value, the FR is entirely true, my lord. Then also, my lord, 417 is bailable. 352 is bailable, my lord. Only 153A. What is the ingredient of the 153A in this affair, my lord? Nothing. There may be this fact may be true. For sake of argument, I may admit
This is item number
28.
30,
28 lords.
28. What is your name?
KM Hassan.
Heard Mr. K. M. Hassan, learned counsel for the petitioner. Also heard Mr. K. Butcher, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Chandan Kumar Haloi, who is apprehending his arrest in connection with Gitanagar Police Station, case number 54/2023 under section 417, 352, 153A, 506, 34 of the Indian Penal Code. The gist of accusation in this case is that on 20 February 2024, one Raju Prasad had lodged an FIR before the officer in charge of Gitanagar Police Station, inter alia, alleging that the petitioner had some outstanding due towards the informant of the FIR regarding the goods and services availed by the petitioner in between March 2023 to May 2023, and the outstanding due was to the extent of rupees 25,000. It is also alleged in the FIR that on 19, which is the date of incident? Mr. Hassan,
Yes, my lord. My lord, it is 19, my lord.
19?
Yes, my lord.
Which is the date?
The date is not, it's 19, my lord.
19th of what?
19 February, my lord. 19 February 2023.
Where it is mentioned?
It was not mentioned, my lord, but as per my knowledge, my lord, 19. One day earlier, my lord. The next day, lord, this.
On the date of incident, some altercation occurred between the informant and the petitioner, wherein the petitioner threatened the informant to kill him, and also threatened that the informant Raju, who is a non-Assamese person, will have to leave Assam if he tries to fight with the petitioner. On receipt of the said FIR, Gitanagar PS case number 54/2024 under section 417/352/353A.
153 AM.
153A/506/34 of the Indian Penal Code was registered. Learned counsel for the petitioner has submitted that all the sections of IPC under which the case has been registered, except section 153A, are bailable. Stop. He has also submitted that even if the allegations made in the FIR against the present petitioner is taken on its face value, no offense has been made under section 153A, as the said of provision is applicable only if there is only if the actions of the accused promotes enmity between different groups on the ground of religion, race, place of birth, etc. However, in the instant case, the only allegation is that petitioner had threatened the informant Raju Prasad only, and therefore section 153A is not applicable to this case. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Gitanagar PS case number 54/2024 and has submitted that there are incriminating materials against the present petitioner in the case diary. And some of the witnesses have
Corroborated, Lords. That part is there.
also made statement against the present petitioner. What they did try to do,
Actually,
They were seen-
both the persons was beaten by the accused petitioner, Lordship. That statement was made by the employees of the accused petitioner. And one of the employee, lady, who is also looking after the CCTV, because the allegation was there that the CCTV footage was deleted. And one has stated in his statement that it was not deleted. But there was the incident.
beating allegation is not there.
Lordship, that allegation is there, Lordship. Uh, In the FIR, Lordship, it is in the para 1 that was they have stated.
Where?
Lordship, it is page 13 of the petition, Lordship.
Which line?
It is in the sub-para 1, number 1 is there, Lordship. Mr. Sondon Haloi had held me, Bhaskar Talukdar, on my chest and dragged me out of his room. The mobile phone of Raju was snatched when he tried to make a video of the attack. He had further ordered his subordinate to switch off the CCTV camera of the premise.
I have considered the submissions made by learned counsel for both the parties and have perused the materials available on record, including the case diary of Gitanagar PS case number 54/2024. Though there are incriminating materials in the case diary against the present petitioner, however, considering the nature of allegations made in this case, this court is of considered opinion that custodial detention of the present petitioner may not be necessary for fair completion of the investigation of Gitanagar PS case number 54/2024 if the petitioner cooperates with the investigating officer. In view of above, the petitioner is hereby directed to appear before the investigating officer of Gitanagar PS case number 54/2024 within a period of 10 days from the date of this order and cooperate in the investigation. if he does so within the stipulated period of time, in the event of his arrest, in the aforesaid case, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2.
And Lordship, date of incident is 20/2/2024 as per the city laws. Statement is there. I have confirmed that. It's not 19, it is the same day affair was lost, 20.
Okay, I have not mentioned.
That's a pardon me, Lordship. Lordship, on which date I have to,
Send back the case diary
on which date I have to appear, my lord?
within 10 days.
Obliged, my lord. Deputy.
May I please your lordship? 439 application lordship. Petitioner was arrested on 22/2/2020 lordship. My lord, in this case, petitioner is inside the jail for about 4 years, 1 month, 11 days. 1,501
Date of arrest is 20.
Date of arrest is 22/2/2020.
4 years.
4 years, 1 month, 11 days. 1,501 days. So in this case, my lord, lordship passed the, initially lordship, in this case, Chargesheet submits, final complaint submitted against, total, 5 number of accused, lordship. Lordship will find it on page number 39. Against 5 number of accused, the final complaint submitted, and out of 5 lordship, accused number 1 expired during the trial. Then in charge sheet, witness number cited to 11 number of witnesses cited, and then out of 11, only 5 witnesses examined. Then in the month of 17 February, 17 February 2023, last witness examined. Till since then till today, no witnesses examined by the prosecution lordship. And because of that reason, your lordship passed the order for against the other co-accused. It is in page number 81. It starts from 81. And other co-accused also thereafter got bail from dishonorable court.
Out of 4 remaining accused.
4 remaining accused, already 2 granted bail by dishonorable court. Because of this long incarceration also. Charge frame on 11/11/2021. And last witnesses examined on 27/2/2023. So in this case, lordship, regarding the speedy trial, I would like to place the section 36, lordship. May I read the section 36, lordship?
Yes.
Lordship got it.
36 of.
NDPS Act.
Okay. Read it.
36, only 36.
Yes.
Constitution of Special
Special
Courts.
courts.
The government may, for the purpose of providing speedy trial of offences under this act by notification in the official gazette, constitute as many special courts as may be necessary for such area or areas as may be specified in the notification. So, for the purpose of speedy trial, these courts, special courts are constituted as per this section 36. So these cases are handled by the special judge. With the intention of the legislature was that, Lordship, to speed up the trial. So in this case, 4 years, 1 month. That is the thing. And thereafter, what happened, Lordship, in our High Court, these are the case till since 2013. It was the summon procedure case. After that, what happened, in his lordship mind, it was that, Lordship, in that order it is passed, that with the intention to speed up the trial, that changed into, Lordship, its warrant procedure case. So it was the direction to adapt the older procedure as warrant procedure case in 2013. In Haji Samsullah Talukdar case, Lordship, 2014, Lordship. Because in summon procedure cases, what happened, Lordship, witnesses first, after filing of final complaint, they have to appear before taking the cognizance, they have to appear before the magistrate, and then again, after taking cognizance, again, they have to come there. In this way, they have to appear before the trial court in thrice. So that was the intention of this honorable court that time. That should not be happened. Because of this reason, Lordship, that honorable court at that point of time, in threadbare discussion, appointing the amicus curiae also, Lordship, the law has been decided and entire law change in the Assam. This order circulated to the trial court, Lordship, in the last, in para 23, it is mentioned, and then it is mentioned
No,
in
whether in Assam a different procedure is followed and rest of India different procedure is followed. No,
right now, what
everywhere same
Ev-
procedure is followed.
No, at that time it was not followed, Lordship, because of this order, Lordship, or all the scenario change in Assam, Lordship.
Okay.
Before that, Lordship, it is mentioned specifically, Lordship. Before that, the procedure was adopted by the cases based on the complaint, Lordship, because they are officiating on behalf of the office, Lordship, and they filed a complaint. This is not the
In NCB
cases,
cases.
NCB, DRI and customs.
Okay.
So, whatever the cases based on the complaint, they have to adopt the procedure of warrant procedure case and they follow as per warrant procedures. So that is the law at that time, Lordship, because
Complaint is to be treated as Chargesheet.
Yes.
Similar to Chargesheet.
Yes.
And warrant procedure will be, sessions procedure will be
Yes,
followed
special procedure is following.
without committal.
after 2013,
Okay.
after the judgment, Lordship.
Okay. This judgment clarified it.
This is clarified by this honorable court, Lordship.
Okay.
That it is specifically mentioned in para 19, Lordship, 18, 19. It start from in para 15, Lordship, Thana Singh judgment is also there, Lordship. After Thana Singh, this was decided, Lordship. In recent judgment of the Honorable Supreme Court given in the case of Thana Singh versus Central Bureau of Narcotic reported 2013, Honorable Apex Court has emphasized expeditious and speedy trial of the offences under the NDPS Act. Their lawsuits have issued various.
There is no dispute to this fact.
No, I am on what, Lordship? Actually, with the intention to expedite the matter, this law has been changed entirely. So thereafter, they are taking lots of time. Before that, Thana Singh judgment, Thana Singh is there, Lordship. In Thana Singh, Lordship, direction was that nobody can take adjournment without any valid reason. Day-to-day hearing was also directed in the cases under NDPS Act. 309 is there, Lordship. 309.
Yes. Anything else?
Why the law changed? Because they wanted, his lordship wanted to, or our High Court thought about that this should be expeditiously complete the trial. There should be expedite this matter. That is why this law changed, Lordship. Now, Lordship, a person inside the jail for about 4 years, and that too even they are these are the witness of their office, from their office. That's the thing, Lordship. Why they are not coming? Why they cannot complete the trial within a stipulated time? In this case, we made several requests to the trial judge as well as the learned special PP, Lordship, to bring the witnesses.
There are only 11 witnesses.
11 witnesses. Out of 11, only 5 witnesses are examined.
Six.
Huh?
Six.
6? Okay, 6. Then, Lordship, regarding Thana Singh question.
Yes.
In Thana Singh, Lordship, it's para number 8, last portion, Lordship.
Para 8.
Para 8, last portion. Before that, kindly have a look at 309, Lordship. 309 of CRPC. Power to postpone or adjourn proceedings. In every inquiry or trial, the proceedings shall be continued from day to day until all the witnesses in attendance have been examined, unless the court finds the adjournment of the same beyond the following day to be necessary for reasons to be recorded, provided that when the inquiry or trial relates to an offense under section so and so, be completed within a period of 2 months from regarding that has been explained. So in proviso last, no adjournment shall be granted at the request of party except where circumstances are beyond the control of that party. The fact that the pleader or party is engaged is another court shall not be ground for adjournment. Where a witness is present in the court but party or his pleader is not present, or a party or his pleader though present in the court is not ready to examine or cross-examine the witness, the court may, if things fit, record the statement of witnesses and pass such orders as it thinks fit, dispensing with the examination in chief or cross-examination of the witness as the case may be. So same in the Thana Singh Lordship in para number 8, second paragraph, page number 594, last paragraph, Lordship.
Yes.
May I read, Lordship?
Yes.
The fourth proviso deserves immediate notification in lieu of the lacuna created by its conspicuous absence, which is interfering with the fundamental right of speedy trial. See, Usainara Khatun versus State of Bihar, something this court is duty bound to protect and uphold until the statutory provisions are in place. We direct that no NDPS court would grant adjournments at the request of a party except where the circumstances are beyond the control of party. Same repeat in this case also. This except must be treated as an exception and must not be allowed to swallow the generic rule against grant of adjournments. Further, where the date of hearing has been fixed as per the convenience of the council, no adjournment shall be granted without exception. Adherence to this principle would go a long way in cutting short that queue to the doors of justice. So in this case, no adjournment should be granted to the either parties, either to the day-to-day hearing. Matlab, before that, paragraph number 4 also important.
In this case,
Hmm.
two others are already on bail, who were similarly situated.
Lordship, yesterday Lordship has fixed some matters on Friday to consider this aspect of the matter, where long incarceration is a ground for grant of bail.
Yes, yes.
I'm preparing on that. I'll address Lordship on that day.
Then let
No,
us,
Lordship, actually, two already granted bail in this case on the similar, under Lordship passed the order in the month of,
you have not challenged that order.
No, Lordship, not required to challenge it, because that cannot be a precedent.
My lord-
I'll satisfy your Lordship.
no, Lordship, on that ground,
Then-
I would like to place that
Then
Lordship.
in a same case, similarly situated, in the same case, same facts, similarly
Lordship,
situated,
Facts are different.
no,
I'll
in
check.
this case.
Yes, Lordship.
In this case
In-
also, as
involvement-
regards
Involvement of
accused-
involvement of the both accused are
different.
different.
Okay.
No, they not different. In Indra Kumar Bania, Lordship Batara,
Let me friend complete argument.
Yes,
and it is-
let me, this was passed by this honorable court at 10/1/2020.
No, will you answer today?
Lordship,
Otherwise, we will fix it on,
Friday,
the-
Lordship.
Lordship,
to-
that day it will be chaos.
no, that
Lots
day
of,
we will
lots
take,
of cases fixed by.
we'll take up only NDPS matters
Yes,
on
Lordship.
that day.
Lordship has
Only
fixed at 2
your
o'clock.
three matters are there.
But Lordship, I answered this thing, what Lordship query was yesterday. That is why Lordship, on 10/1/2024, the Lordship passed the order in this regard, and another one.
Otherwise, it appears that if they are similarly situated, then he will get benefit of the.
Even then, Lordship, Tarun Kumar says that I'll place all these.
Okay.
But this was not challenged till today. And Lordship, what happened?
No, of course, Lordship, this is a very
On
objective.
my query,
On query of the court, I have stand up. No.
you both of you are there to assist the court.
Yes, absolutely, dear Lordship. But Lordship, what happened? And second one is passed by this honorable court on 19/1/2024. Since that date till today, Lordship, no witnesses examined by no effort was made by the public prosecutor before the trial court to conclude the trial, Lordship. And they are the similarly situated person, Lordship, and they are arrested in the same vehicle on the same day, at the same time. Rather, from the Indra Kumar Bonia,
Okay, otherwise it appears your case is that since similarly situated co-accused have already been granted bail.
that is one aspect, because he said that Tarun Kumar is there, parity should not be granted. So that I will answer that, to that regard. But thing is that Lordship, long incarceration is one of the reason, Lordship. To that regard, Thana Singh is there, day-to-day hearing also directed in the Thana Singh Lordship in 2013 without any adjournment. Thereafter, same judgment which I placed before this honorable court. I was in this case, it is not under NDPS Act, but it is regarding Article 21. It is decided after trade by discussion, Lordship. It is decided that
In Thana Singh,
no.
which case?
After that, Lordship, after Thana Singh 2017, it's Hussain and others. In this case, regarding Article 21, discussed thoroughly, Lordship. How the cases should finish in session tribal cases.
2 years.
2 years.
Which paragraph?
Paragraph number 29, it is summed up, then 29.1.2. The sessions, last line, sessions trials where accused are in custody be normally concluded within 2 years. So, with the intention to follow the Article 21. Then Lordship, yes, Ravi Prakash also, no?
Okay, you need not to repeat because you have already, you were the counsel for the
Yes,
co-accused also.
yes,
You have already mentioned those cases.
yes.
Now let him reply
Then
or
Rabi,
anything else. Ravi Prakash is
Rabi
there.
Prakash is there. Rabi Prakash is there. Mohammed Muslim also are there, Lordship. Thereafter, some judgments I place in earlier one, I can place that. Huh? Oh, already in this case, I placed all these judgment.
In the earlier case,
Yes,
you
I
have,
placed
you are relying on the same citation.
same citation, Lordship. In I think Mohammed Muslim and Rabi Prakash, I did not place there at that time.
Okay.
In Rabi Prakash, Lordship, in paragraph number 4, it is mentioned as regards to the twin conditions contained section 37 NDPS Act, Learned Counsel for the respondent state has been duly heard. Thus, the first condition stands complied with so far as the second condition's reformation of opinion as to whether there are reasonable grounds to believe that the petitioner is not guilty. The same may not be formed at this stage when he has already spent more than 3.5 years in custody. The prolonged incarceration's general mitigates against the most precious fundamental rights granted under Article 21 of the Constitution. And in such a situation, the constitutional liberty must override the statutory embargo created under Section 37(1)(b) Roman 2 of NDPS. So, because of this Article 21, Lordship, this is guaranteed under Constitution of India regarding the fundamental rights of the accused who is prolonged incarcerated inside the jail. So, to that regard, Muhammad Muslim also in the similar putting, though 436 is and half of the punishment they should be completed. Same thing discussed in the 2013 by our High Court. And in one case, Lordship, in 1994, Lordship, Supreme Court of Legal Aid Committee representing under trial prisoners and Union of India and others. In this case, also thoroughly discussed, it is mentioned in the Muhammad Muslim. So regarding Muhammad Muslim, Lordship, it is mentioned regarding 37. What my learned friend is would like to submit, I may not know to that regard, but 37 is there. That is there, Lordship, but we cannot override the rights of the accused person guaranteed under Article 21. So it is also mentioned in Muhammad Muslim, Lordship, in paragraph number 20, 2 lines, Lordship, last 3 lines. Grant of bail on ground undue delay in trial cannot be said to be fettered by Section 37 given to imperative Section 36A, which is applicable offences under NDPS Act 2.
Which para?
Paragraph number 20. It starts from 19. A plain and literal interpretation of conditions under Section 37 would effectively exclude grant of bail altogether, resulting in the punitive detention and unsanctioned preventive detention as well. Therefore, only manner in which such special conditions as enacted under Section 37 can be considered within constitutional parameters is where the court is reasonably satisfied on a prima facie look at the material on record and that the accused is not guilty, and any other interpretation would result complete denial of the bail to a person accused of offences as those enacted under Section 37 of NDPS in 19, paragraph number 19. Then the standard to be considered therefore is one where the court would like at the material in a bold manner and reasonably see whether the accused guilt may be proved. The judgments of this court have therefore emphasized that the satisfaction which courts are expected to record that the accused may not be guilty is not only prima facie based on the reasonable reading, which does not call for meticulous examination of matters collected during investigation. Grant of bail on the ground of undue delay in trial cannot be said to be fettered by Section 37 given to imperative Section 36A, which is applicable to offences under NDPS Act 2. Referred Satyendra Kumar until Supra having regard these factors, the court is of the opinion that in facts of this case, the appellant deserved to be enlarged on bail. If the trials are not concluded in time, the injustice wreaked on the individual is immeasurable. Immeasurable. So that's the law, Lordship. That's law laid down in this case. He is inside for about 4 years, 1 month. And the person, the petitioner, having a son, Lordship, who is completely autistic person, Lordship, we have annexed the document. Whose responsibility upon
What
him.
was the seizure here?
Seizure, Lordship, morphine. 4 point,
Morphine.
Lordship.
How much?
4.15 kg methamphetamine from 5 accused persons who were boarded in the vehicle. I can argue on that point also, Lordship, regarding 42 and all. But in that case, 42 is required, though that is there. But that is not followed, Lordship, but Lordship, at this stage it's a trial, it is a matter of trial. So Lordship will argue on at the time of argument before the trial court, Lordship. Because, Lordship, it is the recovery from a vehicle, Lordship, private vehicle. To that regard, Lordship, there is a apex court decision, Lordship. To that regard, if they search a private vehicle, in that regard, Lordship, 42 must have to comply. And proviso is there, Lordship. At the night, they have intercepted the vehicle. That time, authorization is required. That is not there in our case. 42 is there. They, on the basis of the information, they reached the place and they intercepted the vehicle. But to that regard, the interception, as it was in night, that to that regard, Lordship, proviso, authorization is required, Lordship, as per the proviso. So that is not a line of argument right now, Lordship. But thing is that he is inside the jail and the co-accused already got bail, and the other person, I think he has filed a bail application. So this is my sum.
Okay, let him reply. When will you?
I'm not ready with judgments. What's the fixed on Friday along with all the matters?
Okay, let him
Because
reply.
common question is that long inclination. Whether parity can be a ground granting to.
Heard, Miss S.K.
Before passing on, Lordship, my only, I want to know only one thing: how much time they will take to complete the trial? Trial. Because this,
Trial, they
no, NCB should decide how much time they will take.
No, let me decide your bail application.
Lordship, in our bail application earlier in 2013, this honorable court has decided these things, Lordship. In bail application, Lordship, you can peruse that thing.
Okay. Heard Miss S.K. Nargis, learned counsel for the petitioner, who has completed her part of the submissions. However, Mr. S.C.K.R. learned additional public learned special public prosecutor NCB prays for some time to make submission from his side. The prayer is allowed. Let this matter be lifted again on 4th of. It is fixed on 4th.
4th on at 2 p.m.
4th of
And it will be series.
April as a part third matter.
What's if items 16, 18 are same?
16.
Same point is there.
16 and 18.
16 to
Kajal did not.
18 report to them. What one?
How about it?
16 to 16.
To continue.
Huh?
16, 18
Maybe
we had along with all the matters.
Same.
Because common question
16 and 18.
Is in 16, Lordship, 4 years, 6 months, 25 days.
16 also 16.
16 and
18.
Heard
18
letter
also.
counsel. And
on 4.
For that 2 p.m.
My lord, I am having item
Obliged.
number 39, last item of hearing.
We
There
have
is no
time.
possibility to reach. So it may be fixed some other date.
6 on 4. This matter is getting left over all the time.
you are petitioner in person,
I'm
He is appearing
respondent in person.
respondent in.
And it's such a critical case.
Okay, no, I am not hearing now. We will fix it as per your. When-
On 4th.
Fourth may be difficult.
4th may be difficult. Which tomorrow, even if it's not a hearing day,
This week is, has been
He
declared
not
as
take.
motion week. Let it be after Bihu,
After Bihu,
any date.
any day after Bihu, on the first hearing day after Bihu. Your lordship.
My lord, I can just fix it 17 without my knowledge. Someone.
Interim may continue.
Morning.
Be patient. I'm coming. Because we still have more than 1.5 hours, but we have a VC.
So after Bihu, any date may be fixed and interim may continue.
This is item number
39.
39. Bihur pisot khula date kar diyo.
वहाँ चले गए.
2nd May
2nd May.
would be okay. Okay, before 22nd will be okay. 18th April. 18th April, 18th of April,
Okay.
interim shall continue.
Interim.
Lord,
Oblige.
I have criminal appeal matter 34.
Yes.
34. It may
No,
be
no.
fixed on 9th. May
34 on 9th.
May be fixed on 9th.
Okay.
Lordship,
Yes.
my matter
Ninth
on
of
the
April.
morning time.
No, your matter we have found out it was due to some mistake on our part. The mention was made as regards item number 19. 19, but
Okay, Lordship, but my CD has come tomorrow, may be taken up.
okay. Huh? Okay.
In regard to item 15.
Item number 17 tomorrow.
Tomorrow.
Item 20 also,
okay.
your lordship, there is.
Yes,
the-
Mr.
Lord,
Doctor.
Item 15. My lord, can it be taken by your lordship the day after tomorrow? This is a short matter.
Day after tomorrow, we are having this NCB matters.
On 5th.
Item number 15. Item number 15 on 5th.
Item number 22. It is already covered over the statutory period 60 days, Lordship. Arrest on 3/2/2024 and today is 2/3/2024. Section is 420 and 406 only.
We'll take it up today. We'll take it up as last matter.
Today. Oblige.
May I please, your lordship? Item number 36, if time doesn't permit today, lordship, then can it be on 9th, lordship? Because here also for a long time, he is behind the bar. 36, lordship. 351/23.
36 is a criminal revision.
No, it should be a criminal appeal, lordship.
Criminal
Banu Sargari,
item number
38, item 38.
38.
Lordship, may kindly fix it on 9th if it is possible, lordship.
38 on 9th.
Deeply. Item number 21.
It's on 9. Record.
21 on 9th.
Lordship, criminal appeal.
Item
Then will be fixed. Item number 30. 6 April, Lordship.
Item number
30.
30 is for orders only.
Yes.
Let it come next week, any date. We are not fixing date.
April is in jail, Lordship.
One, 8/4.
Oblige, Lordship.
Lordship, item 20, your lordship, there is CD is also there, your lordship. I'm praying on, if it is not on today, then on tomorrow, your lordship.
Today we are having a hearing, so it may not be possible.
Then on tomorrow, your lordship.
Tomorrow we don't know what will happen. Okay, let it be on tomorrow.
My lord, item number 7, my lord, 22nd of April,
22nd April, item number 7.
7, my lord.
Okay.
May I please, your lordship, lordship, I'd like to mention item number 23, can it be taken up tomorrow, lordship? Say a case study is there, lordship, item 23 and 46, lordship.
Tomorrow, highly apologize.
May I please, your lordship. Item number 27, my lord. Interim may extend, my lord.
27.
27. We have interim in this matter.
27 interim will continue.
So item number
Public.
44, Lordship. Can it 22nd April, Lordship? 44
44 on 22nd.
after vacation.
Wait, please, your lordship. Lordship, item number 26, interim may continue, lordship. 26.
Item number 26 interim shall continue.
Much obliged, lordship. Item number 35, lordship. Kindly fix it before before.
35
35.
on 22nd. Yes.
My lord, as regards to item number 24, my lord, the person is behind the bars, my lord. So if I pray, my lord, that on the 5th, it may kindly be taken up. 24.
24 on 5th.
Yes, on
Diary is
5th.
there.
Diary is there, my lord.
Diary shall be
Diary-
written.
24.
It shall be written.
Yes, my lord, diary. That will be much of.
Well, item 25, there is interim matter. That may continue.
25 interim shall continue. Date to Miladi. Yes, Nagaland. Nargis or Tessa? Yes, Mr. Chaudhary.
May please, your lordship.
Your part is still remaining.
So I have not started here.
No.
Reply part.
Question of starting does, now you have to finish.
Yes, reply. But I am not.
Only
getting it.
reply.
Yes, reply.
Yes.
Reply, your lordship. May please, your lordship. Here, your lordship,
What was the last date of hearing?
last date of hearing was, your lordship was. It was in the last month, I think. February, I think. Sorry.
25th of January.
No, after that also there was that.
The last hearing, your lordship, 20 February 2024.
Which date?
20 February 2024, and after that it was taken up on 27th February 2024.
Yes, yes.
27, we could not
Yes,
take up.
Yes, you can.
On
It was
20
15 February.
Yes. 24th March.
Lordship, on that day I finished my
Yes.
submission.
15 February was the last date of hearing.
Oh.
You have to
Yes.
20 February, 20 February.
Okay. Yes, Mr. Chaudhary.
Your lordship, on the last occasion, my learned friend has made a statement that Assam Police Manual governs Nagaland drill, but there is a Nagaland Police Manual which is there, your lordship. In fact, in my written submission, I have put one, some portion is there. So Nagaland Police Manual has to be seen also, your lordship, in this respect, because what that is what I just come to those of later on, your lordship. Now, your lordship. Now, your lordship, I am taking IA 5 of 2020, criminal provision 5 of 2020, that I am taking, your lordship. Because there are certain things that you have to show. Because my learned friend started
Putul,
criminal petition number 5 of
IA5.
5, IA5, IA9 also, they will give the entire set, your lordship, the reply, everything is there. IA5, your lordship, basically.
Yes.
Your IA5, which I filed, your lordship, it is pertaining to the prayers under IA5, your lordship will see. Prayers are regarding the first charge sheet, your lordship, which has been taken away by them. Yes, your lordship. In that, they have filed an affidavit, your lordship, whereby affidavit, I told your lordship there are 2 charge sheets. It has been reflected in their affidavit itself, your lordship.
Para?
Page number 3, if your lordship, is para 5. If your lordship will see mentioned at the case number 1, that middle, after middle, charge sheet number 3 are dated 22/11/2021, your lordship. This is the first charge sheet, your lordship. And if your lordship see the compilation of the charge sheet which I have given, if your
No,
lordship.
no. What have you shown in the affidavit filed by the
Yes.
opposite party?
Yes, sir. They have stated that their charge sheet 3 of 2000, this 22/11/2021, the charge sheet is there.
Which para?
Para 5, your lordship, see their affidavit. Para 5.
Yes.
My lord has got it. Charge sheet
Yes.
number 3 of today. Then, if your lordship take the
No,
compilation.
para 5 mentions about the charge sheet.
Charge sheet number 3 of 2020, dated 22/11/2021. This, according to you, is the first charge sheet, your lordship, which is not on record. Then, how this is a second charge, if your lordship take the compilation, first page, if your lordship will see, compilation which you have given that, first page, if your lordship see.
What they have stated in para 5?
Para 5, they have said mention as to how they have taken back the charge sheet.
Based on the above admission.
Yes, mention may be made in that case. So charge sheet number 3 of 20 was forwarded to Officer and SPS Nagaland and also through the conducting prosecutor. Subsequently, prosecuting inspector of police staff processed the charge sheet to file after necessary entry, same put on record. Learned PP conducting scrutiny of charge sheet encloses same put honorable judge to verify if there is deficiency present there. The public process produced the office charge sheet was filed on 23/11/2021, is said, which is well on record. However, on further course of scrutiny, Learned tactic PP had detected some discrimination for which the Learned PP has sent an early review. On detection of some discrimination which requires activation, the file was duly returned to IO in the middle part of December. In this regard, they have admitted the allegation against them by me, your lordship, in that application, your lordship, that they had in the middle of, they have taken back the charge sheet. My case is that charge sheet cannot be once in the custody, they cannot be taken back, your lordship. And the fact that there are 2 charge sheets is proved by page number 1 of that compilation also, your lordship will see. This charge sheet is charge sheet number 03 dated 14/3/2022. First page, if your lordship see, of the compilation, that charge sheet compilation. Where they have begun charge sheet, if your lordship see, dated 14/3/2022.
Yes.
So, your lordship, here I have shown that 2 charge sheet, your lordship. And so far as the issue of who can, whether the PP has any role in before submission of the charge sheet, if your lordship see the provision of CRPC also, he comes to defend, he doesn't have any role in the submitting of such charge sheet, your lordship. That I'll show it from your lordship. Nagaland Police Manual, I've got this thing, your lordship. I just got photocopy for your lordship. This. So they are in 6 parts, your lordship. I've given that earlier part also the detailed submission relating to the duties of the police officers also. Their charge sheet things has been given, your lordship. We'll see. Because I want to show that PP has no role here.
Okay.
If your lordship see, next second page 204, if your lordship see, the charge sheet in this report prescribed section 77 is to be submitted to Congress case when the accused is sent up for the absconding so and so criminal procedure. The charge sheet will be numbered consequently there. The forms, these are the column. Then if your lordship down below all column 7, the charge sheet annexed to the charge sheet must be carefully filled in. See the following rule. They said then if your lordship see next 205, again certify the accused basically IO is there. No role of PP at all, your lordship. 205 if you say middle, certify that the accused this is also IO is there. Then here if your lordship will see. In this connection, the finger this if you when the entry regarding previous conviction so and so is just received it, below the certificate investing at the court officer signed the certificate as for certified. I have carefully searched the conviction reason and found that the court officer. Then if your lordship will go to 207, next page. As soon as the possible after the charge sheet has been substantiated against an offender in charge sheet must be sent quickest manner to the court officer for submission to the magistrate, your lordship. In the motor action, we are not concerned, your lordship. Then if you are down below, if list of properties so and so, charge sheet in cases referred to the magistrate to police authority must be put in by the court officer, in particular magistrate who directed investigation. So there is no direction for further investigation. So charge sheet once filed is then 209 if your lordship see. 209. Instructing regarding submission of final report. The either it is final report or in the form of charge sheet, either of it. Final report form also concerns section 77. It is submitted in all cases in which the accused is unknown or there is sufficient to justify trial of a person accused or arrested which the charge is for. The bail one so and so your lordship will say. Then if your lordship will see down below, the final report form must be submitted immediately on completion and the actual data discharge clearly submitted. All final forms to charge sheet circle inspector SDPO. So no roll out. Final reports in cases referred to always police must be put up by the court officer to particularly for directing investigation. So there is no question of taking back the thing, your lordship. Then your lordship, if I take your lordship to the provision of CRPC. CRPC, if your lordship will see.
Yes.
Yes. CRPC, if your lordship see the provision of CRPC, if your lordship see, it is what is the role of PP, your lordship? PP's role, if your lordship will see, if it's can I have your lordship take the CRPC, if your lordship, for a minute moment, your lordship. Investigation is that H. Investigation includes all proceedings under the code for the collection of evidence conducted by a police officer or by any person other than a magistrate who is authorized by in this behalf, your lordship. So investigation done by that person, your lordship. Then if your lordship will see public prosecutor definition of public prosecutor U means any person appointed under section 25 includes any person acting as direction of public prosecutor. Now I take your lordship to section 24, your lordship. Section 24 says, your lordship, public prosecutors. For every high court, a central government or a state shall, after consulting the high court, appoint a public and may also appoint one or so and so. Your lordship, this is for conducting in such court any prosecution, appeal, or other proceeding on behalf of the central state. So here it's very clear. PP has no role till the charge sheet is filed. He comes only when after charge sheet is filed before the court, your lordship. So here, before the charge sheet, according to the before the charge sheet, the PP has no role. He cannot interfere the investigation agency, your lordship. This section is very clear on that. So here, your lordship, here it is very clear that this cannot be done.
Yes.
Then if your lordship see what that what the PP has done, that also I'll show your lordship. That is available, your lordship. That is available in the reply also, your lordship. Yes. If your lordship take the criminal petition 9 of IA number 9 of 2022, there the document is there. IA, their reply, your lordship. IA number 9 of 2022, if your lordship see page 6, annexure 2. If your lordship see it, the charge sheet, my lord has got it, page 6.
Yes.
The charge sheet CS case data of the case which is enclosed are perused and observed the following. That a seized drug in the instant case launched. Page 6, your lordship. Page 6 of this, their affidavit in opposition. I'm reading from the document. Page 6, my lord has got it. Page 6.
Yes. Vera?
Now, page 6, your lordship, this is my PP, your lordship, the public prosecutor, your lordship. So here, if your lordship will see,
Page 6 of their rejoinder.
No, at affidavit, you know, this one. 9 is the part. 9 of 2022, their reply. The other IA, you know, that document is other IA. That's why they have to suffer. This is here, your lordship. Their file is here in this thing.
No, 9 of.
Yes, 9 of 2022, page 6. Annexure 2, if I order get it.
They're all mixed up. Acha, 9.
Yes. Here, if you see, it's a PP has submitted a report, concise memo. The charge sheet and case diary of the case with its enclosed are perused and observed the following. That the seized drug in the.
Where are you reading?
Your lordship.
Where are you reading?
Page 6, your lordship. That's
page
6
is
PP, your lordship. So here, what he has done, he has tried to refresh the investigator. That he doesn't have the power, your lordship. IO has the full power to submit. It is after the filing of charge sheet when the before the PP role of PP comes, not before that. At the time of filing of charge, he has no role at all. That is what I am trying to submit, your lordship. What they are trying to show that PP has taken back the thing and he has rectified the charge sheet and filed it. That is not his purpose. That is not his role, your lordship. PP, because Act doesn't provide that. Nor the Nagaland Police Manual was giving that power. That PP will see the charge sheet before filing it, and he'll interfere. That cannot be done. That is totally. This is what I am to show, your lordship. Now, your lordship, on the when I was arguing the matter, your lordship asked me a query regarding that taking of the documents from the custody of the court, your lordship. That document which, your lordship, whether this document has there or not, that is also there, your lordship. That I have filed in this one. IA number 9, it is there, your lordship. IA number 9, if your lordship will see, as at page 19, if you have page 20, if your lordship will see, this document is there. That this was taken back to the custody of the court. Your lordship was asking how you have got the document, and this was filed by me here. Then type is there. Then this is a special case record is there. Next page, your lordship, annexure P21. These documents, your lordship. So here, taking with the charge sheet, if you are charge sheet and all relevant enclosed and original in such a crime case, some so it has been submitted to court master, if you are see. Page 20, my lord has got it.
Yes.
Page 20. So it was filed on so and so. Court master's signature is 23/11/2002. Then, if your lordship, there is an entry in page P21 also. This is the entry made in 221, your lordship. It will be typed in the next page, your lordship. So it was taken back.
this thing. Your Lordship. This document was filed and this was not denied by the respondent in their affidavit, Your Lordship. I made a statement in para regarding this document, Your Lordship will see, that is at para 14, Your Lordship. Para 14 of the application, if Your Lordship will see, page 12. My Lord has got page 12, the para 14. The respondent has filed the first charge sheet along with all relevant documents, the principal distinction on 23/11/2021. There is a covering letter that 23/11 addressed to the principal decision and an endorsement from the court of the receipt of charge sheet by the said court. There is another document received dated 15/12 where is the first charge sheet along with the documents returned to Accusations. So this is already specifically there, and they have not denied in the counter affidavit also. That affidavit, if you say para 14, if Your Lordship will see page 3 in the reply, para 10, that with regard to statement made in paragraph 10, 11, 12, 13, and 14 is important, of the applications are denied, which are contrary to records. There is no two charge sheets submitted by record as alleged by the and just question of violation so and so 23. The charge sheet is already with the relied on was sent to a principal district through public question. Through public, the public will verify the charge sheet if there is any deficit present in the charge sheet. And the public person cannot do that. It is the IO who will do. So they have admitted this fact, Your Lordship, and those documents they have not denied, Your Lordship. Now that thing I have dealt in my rejoinder also. I filed a rejoinder in that IA number 9 also. Rejoinder, I'll give you the paragraph also, Your Lordship. Rejoinder, I have pointed out various inconsistencies, Your Lordship. Then if in the rejoinder, if Your Lordship go to page 10, Your Lordship. Para 20, Your Lordship. The respondent in paragraph 10, that is the affidavit. In the affidavit in opposition, having no answer to violation of section 1 CRPC by the IO and the PP and an attempt to sidetrack the issue by bringing in section 170 in order to defeat the claim for supply of the first charge sheet dated 22 by the respondent. The petitioner not claiming any portion contains the case diary. They said case diary if reviewed or taken up in the present case, which could have been subject matter of section 170. The supply of the said document is sought under section 207 of the CRPC and the IO had already supplied a copy of the second charge sheet file along with it on 16/3/2000 along with 20 volumes of documents, which are a compilation is saying. Of the way, the P of section 170 of CRP is not available with the respondent to deny the supply of first charge sheet dated 22/11/2000. The fact that had created serious danger prosecution case and the penalty of the second charge sheet dated against the petitioner violation. Now I read for a convenience, Your Honor, section 170 of CRPC, Your Honor. 172 is diary. My Lord, the section CRPC.
172.
Yes, sir. CRPC. Diary proceeding and investigation. Every police officer making an investigation under this chapter shall day by day enter the proceeding in the investigation in a diary, setting forth the time in which information is received by him, the time which he began to close his investigation, the place and places, detail and statement of circumstance assigning to it. The statement of witness recorded during the course of investigation under section 16 shall be inserted in the case diary. The diaries in subsection shall be volume so and so. Any criminal court may send the police diaries in case under inquiry trial such for and may decide not have evidence in the case but to aid the inquiry of the trial. Neither the accused nor his agent shall be entitled to call for the diaries, nor shall they be entitled to see them because merely they refer to the court, but they are used to the police officer who made to refresh their memory, use it for the purpose of. So here that stage is over, Your Lordship. I am not asking for the case. I said when you file the second charge sheet, where is the first charge sheet? I have shown Your Lordship from the record there are two charge sheets. So now the issue is I am asked for this application is asking where is the first charge sheet? The first charge sheet is missing, Your Lordship. That's the whole crux of the issue. And according to this provision, the PP cannot come into the picture before prior to filing of charge sheet. If there are cases that they have taken back the charge sheet, once the charge sheet is filed, only he comes under section 10.
Okay.
So that is the issue, Your Lordship. Then, Your Lordship, Then my learned friend made a hue and cry on letter date 25/8/2028 to 2018. That letter is also here, Your Lordship, in that compilation, Your Lordship. I'll show you that. In that compilation, I'll show that letter, Your Lordship. It is here, Your Lordship. Compilation, I'll give the page number, Your Lordship. That letter is there. The charge sheet document, Your Lordship, it is just give me a minute.
Page.
Page, it will be, it is 95, Your Lordship, you will see. This what they have alleged against me. Because my letter first started this letter.
What is this?
This is that letter that I have written to GGP about the seizure of this this thing. And it is my case, I came to know on 18/8/2018, not before that. In my statement is everywhere there. Your Lordship will see here. This letter was written under duress, something that I'll show it from the records also. Here, if Your Lordship will see, so and so. Yes, I, as the team leader of Narcotics, decided to trap the real owners of the carriers were two boys who did not reveal anything. They were released on PR bond. They promised that they will bring the real owner to us. So we decided to wait somewhere. The mobile phone numbers have been noted down. However, Director SP Narcotics is going to follow my directive. Your Lordship, this is under coercion. I'll show it from the record also. Sir, on 2/24, I went down to
the letter written by you.
Huh?
You have written this letter.
I'll show you how this letter has been explained. And they have been admitted by PW11 also, that I have threatened him. PW11 is the husband of the OC, Your Lordship, PW2. They are both IPS officers, Your Lordship. So I'll show it from his evidence also. He has admitted that. I'll show it from the evidence, Your Lordship. So I went and delivered to CID branch office. As they have shifted back to the old location, I had briefed of the role and nature of the. Meanwhile, I got a message from ADG Law and Order regarding issue. Had I been the PS under, I would have remained. So I had shifted the whole. Here, it is important, Your Lordship. Here, where is it will amount to NDPS Act comes into or not. I have shifted the whole 11 packets to my locker at my residence. Kept in my custody for safe hotel. This I have admitted here. I say 18 because safe. They were not safe. I took it to my residence. I informed the DGP on 25/8/2018. So they cannot seize me on to another. It was recovered from my possession. I have stated before him that these drugs were in my possession here. These packets are in my safe custody. This letter shows that this letter shows my innocence on that I have kept it. I am not denying the fact that the drugs were not with me. I said on 18th I took these drugs because they have requested me that it is narcotic branch. The night security is not safe. Earlier also some the drugs were stolen. So it was shifted to my residence where we have 24/7 security, Your Lordship. It is stated here, Your Lordship. So this is very important. I have shifted the whole 11 to my locker at my residence police reserve and kept in for safer. In the mid-19, a kg of heroin powder was made missing from this PS locker. So for safer custody, I took it home after telling the SPS and inspector that I'll keep it in the custody till further action. I, the team was here, take the responsibility of my shortcomings in this regard. We just wanted to nab the king and inform the authorities because 99% of the drugs come from Manipur side. It's inter-traders. And according to sources, there are a good number of clients under the factory manufacturing drugs. We haven't got a single kingpin, only carriers and touted. So this is it. Now I take Your Lordship the evidence of PW11. The PW statement of Petitioner under 161, Your Lordship. That is also there, Your Lordship. That is page 48, Your Lordship, 48. If Your Lordship, my Lord has got page 48.
Yes.
The statement of PW Petitioner under section 161, Your Lordship. Here, if Your Lordship, that 25 has been mentioned here also. Here,
no, what you want to show?
Here I have to show that this some question where where I've implicated myself in some way, it's another portion. But I was threatened with life threatening by the by PW11. He has admitted that. So here I am to show Your Lordship. Here it is clear if Your Lordship will see.
If I may be allowed to seek your indulgence, Your Lordship, this is not a trial. It's about the question of the FIR.
Question is 161 statement I have to go through. You have relied on that. I have to demolish your letter also. Why, on what basis it has not a trial? I also know it's not a trial.
So, Lordship, whether it is under duress or not, those will be taken care at the time of trial.
Definitely, I'll show it from the record. I'll show it from here. He has admitted at PW11. If Your Lordship will see, question number 13, if Your Lordship will see. So, page 48, question number 5, Your Lordship will see. On 18/8/2018, OC Narcola IC came to his office chamber and informed it was who had handed over and informed him the seizure requisition save them from the lapse they have committed. OC Narcotics Cell and IC Narcotics told him that it is not safe to keep the concern in Malkhana since there is no armed guard and there is past history of lost item in the heroin in the early 20s. Accordingly, they requested me to take some alternative arrangement for safe custody. They requested him to keep the concern with him for some. By evening 18th, they handed over 11 packets to notary to our service. So 11 packets are handed over to me, Your Lordship. Then I went to this letter. Why do you, he said, then I said, Your Lordship, also check it to you. She had handed over custody, Your Lordship. Yeah. This is 15 is very important, Your Lordship. Question number 15, page 49. In your reply to your show cause notice, signed on 7 times, so it is stated in your report, initially said the brown cigar was directly kept in the custody from 3/8 to 17/18. It was there till, this is the question, it was only on 18 that I instructed SP inspector to hand over the so-and-so, Your Lordship. Now, if Your Lordship go to next page, he has said, he stated that he wrote this report just to save the narcotics since his life was under severe threat from KV27 NPS, so-and-so. This is statement is there. AIG and Narcola Sophie, she is the PW to the OC of the police station. He was under tremendous pressure to save his life threat by SMS dated 26/8. This SMS is also on record, Your Lordship. The report of threat of life is sent to return to DGP and Home Guards and Detention. Now, so Your Lordship, that portion, it is under threat, Your Lordship. Now I take Your Lordship to PW11, his own statement. PW11 statement, I start at page 42, Your Lordship. That is husband of this lady, Your Lordship. Page 42, if Your Lordship got PW. He is an IPS officer, he is also an ASP. Your Lordship will see in that middle, in this tense disturbs, he said, in connection with I am to state that Richard has been harassing my wife. And psychologist since he took IGP in 2018. 2018, the incident happened. When the incident happened, I felt disturbed seeing my wife mentally getting out of action to Richard Into. In this tense disturbed frame of mind, I have sent an SMS to Richard Into warning him that I will not leave him if anything untoward happened to my wife because of his authority. I have taken Richard Into action of defaming my wife, subordinate of narcotics. In this, I was planning to initiate legal step in court of the customary court against Richard Into if anything untoward. I did not proceed. But since Richard has replied my assessment, he will bear the responsibility and nothing will happen to my wife. So it is under threat, he said.
No,
then
it does not say that you give a letter under
threat. No, that is that threat portion is coming up, Your Lordship. That is, let me read further. It is coming up here because that is that portion. I take the responsibility. It doesn't mean anything. I take the as a team leader. I take the responsibility. I'm not saying as a team leader. As an IGP of the police station, I take the responsibility. Then here, if you saw Lordship, but if Your Lordship will see page 43, what do you mean by if anything untoward happened because of his authority? We all know Richard Into action has defamed only not only himself but the whole Nagaland police. Richard Into has done IGPC immediate superior control officer. My wife in the instant case happened to action registering again. By if anything untoward happened because of his authority, I meant to depart mentally, legally, or even physical harm to my wife. Because of the whole thing happened due to his authority directing me not to register a case, who suspended so and so. Then he said, then next para 4, you warned him that you will not leave him in case anything untoward happened to your author. Giving a warning is a serious thing. Then he said, as mentioned, action has been disturbing my wife mentally, psychology, and was tense at home. In terms of, I had sent an SMS Richard warning him that I will not leave him if anything untoward happens to my because of his author. However, I amended to legalize. So here he has admitted the fact. It is under duress. But that later, some portion, subsequent portion has absorbed the whole thing, Your Lordship. So, Your Lordship, then Your Lordship will, I just take Your Lordship to then then I take the Lordship to later than your order. Then I take the Lordship to this thing. Then I, Your Lordship, then in respect of Your Lordship, in respect of drugs I am coming, Your Lordship, first. That is. If Your Lordship will see just before that, and if Your Lordship will see, while learned friend didn't deal with these issues, Your Lordship, which are specifically raised by me, Your Lordship, these are basically just Your Lordship. Thanks, Your Lordship. One is, Your Lordship, there is no reply in respect why there is no action has been taken at complaint date 2003/8/2018 and first seizure memo 3008/2018, Your Lordship. There is no reply on that issue, Your Lordship. Why they have still not registered any FIR on that thing. That, and if Your Lordship, I have already pointed out that these two documents were, although it's a part of the charge sheet document, nothing has been done on that. No inquiry, nothing investigation has been done. Then, Your Lordship, no reply in respect of under what provision second seizure memo was prepared for the same items and the same did not go out of the custody of the respondent. That I've shown that letter dated 25/8/2018 also shows that if that was the information given for 1/9, it cannot be seized from me again. They knew it is in my custody. There's a question of possession doesn't come here, Your Lordship. So no reply in respect under provision second seizure memo was prepared, same item. There cannot be second, they have not replied. Once first seizure memo is there, they cannot go for second seizure memo of the same items. It can be done if they have lost the item and it is recovered again. It is not so. It is kept, the allegation is it is keeping in custody. keeping in custody drugs, not otherwise. It is not said possession of mine, it is possession of mine. I've taken this keeping in custody something, it is keeping in custody is entrustment. It is just entrusting me, I have returned the drugs. There is no discussion about the first charge, first seizure memo that I have already stated. Then they are totally silent about the first sanction order 39/2018, Your Lordship, by which the charge sheet dated 20/11/2021 was filed, Your Lordship. Even this 39/2018 charge sheet is not on record of the charge sheet. It has been annexed by me in my criminal petition, Your Lordship. It is annexure and just the annexure number. It will be in that criminal petition 27 of 2022, Your Lordship. I'll just that is only I have annexed there. The criminal
Okay, no, I have noted.
Sorry,
Need not to-
that is there. That is there. That's what I'm saying. That is there. Then Your Lordship will see there is no reply as to why 3 prosecution sanction has been taken, Your Lordship. Here, if Your Lordship will see, before filing of the first charge sheet, 39/2021 action, there also they said amendment of section 7A and 7C was taken into consideration, and the sanction was given only under PC Act, not under IPC. Then on 4/3/2022, after they obtained a second sanction, second and third sanction, Your Lordship, for the same offense, Your Lordship. So now they have not replied as to how on what basis 3 prosecution sanction has been obtained. That's not a law. You can have one prosecution sanction is not a plaything. It's a very serious matter. The sanctioning authority has to apply their minds to materials of the thing discussed, and they obtain sanction is obtained. It's not a thing. It's just a routine letter. They can get it, Your Lordship. Your Lordship, because second charge sheet, if you also see second, decided only, dealt with only keeping in custody of say drug by the petitioner also. That's not said this thing. Then if that is so, then PW2 and PW could not be dropped as accused since they are under legal, they had the power to register FIR, GD entries, etc., and which they have not denied, Your Lordship. Then, Your Lordship, they have stated, I have orally said not to give register FIR, that is the allegation, orally. Because I have shown, Your Lordship, under the.
That you have.
Yes, that is there. So they have not replied to that. Then CDR entries in respect are not dealt with. They have not dealt with the CDR entries. How as to, because I have already told that this date came only at, not before that, only at that time was section 161 statement and 164 statements. And in the final charge sheet, the GD entry was put because 161, 164 state doesn't contain that this GD entry has been made on 6/8/2017 and 2017/8/2008. And I have already shown by CDR record on these 2 dates he was in Dimapur. That's their own CDR records is showing that. Then, Your Lordship, I made a categorical statement that it was the whole charge sheet was based on section 161 and 164 statements by the witnesses, Your Lordship. So that can, when they have not dealt with it, the whole charge sheet is based on that. Now, Your Lordship will see section, I have already said section 164 statement was given to 4 persons and two are co-accused. And these are all exculpatory in nature, so that cannot be taken by virtue of section 30. And the other 2 are in the nature of statement, section 164, 5 and 3, PW 4 and 5. Their statement as or as a statement by witnesses, Your Lordship. So this cannot be because I had given judgment to the effect showing that this statement cannot be taken on record, Your Lordship. So Your Lordship, they have not dealt with that. Then another issue which has the diabetes, how you have made the drug. You said they're absconding, they are not present in the same, but drug peddlers have been in prosecution witness in a disciplinary proceeding by this authority. Both that I have shown it, Your Lordship. Then Your Lordship will that I will come to later on. Then CFSL report did not support the contents of the second charge sheet, Your Lordship. Regarding commercial quantity, because CFSL report they have put 4 queries. I'll show that, Your Lordship. CFSL didn't deal with any of the queries. They didn't reply anything. Then there's no statement from them. I made a category statement that after the drugs were seized, taken from me on 1/9/2018, just kept in the custody of police till 5/11/2018. That period they cannot keep it because that is the period where the entire things got changed. According to me, the things may be changed also. Anything happened because 102 CRPC.
No, these things you have already.
I have they have not dealt with it. I'm saying I have argued. They have not dealt with it.
Okay.
That is what I am saying. That these are points which I have argued. They have not dealt with it, Your Lordship. And in fact, in the statement of PW2 and PW, who are the co-accused, they didn't mention in the section 164 statement that GD entries have been made in respect of taking out drugs on 6/8/2008, 2018, 17/8/2018. They have not stated that and they are the authority who makes the GD entries here, both of them. It is under their signatures. So they have not stated on that the 164 statement that is the IO on its own put that GD entries on this thing. So these are all interpreted subsequently. Because this shows the GD entries based on which the case has been made out have been interpreted at a later date, not on that date, because it is not existent on 6/8/2018, but because this chain of events shows that GD entry was not there on till the filing of charge sheet on second charge sheet, Your Lordship. So then another thing they have not explained as to how on what basis they have kept the seized drug in their custody from 1/9/2018 to 5/11/2000. They have not explained it. That specific allegation. They have not dealt with that. PP has not dealt with this. So these are the very categorical issues, Your Lordship. Now, so far I've taken, Your Lordship, the CFSL report. I'm just coming to that. CFSL report, which is that the queries they made and the CFSL, I just take Your Lordship to those things that are very important. Your Lordship, turn to page 77. Page 77, Your Lordship, this is a letter written by IO, Your Lordship, to the forensic expert, Your Lordship. Page 70 is a question for this thing, Your Lordship. Page 70, my Lord has got it. 4 queries are there. Whether the suspected items marked as Exhibit 1, 2, 3 are prohibited narcotic drugs. This is one thing, Your Lordship.
No, this you have already submitted.
Yeah. That's
They have not replied.
No, they have not replied it because here, Your Lordship, if you see the CFSL on this 4 queries, if you see the CFSL, nothing has been mentioned, Your Lordship. So the question of as to what basis they have obtained this commercial quantity was there. Drugs has not been determined. Commercial quantity is something huge, Your Lordship. So section 21C, commercial quantity defined section 21C, Your Lordship. May I read section 21C, Your Lordship?
No, okay.
Because commercial quantity has not been defined in Your Lordship in the definition clause, Your Lordship. A comma is there. If, for your lordship, it is 7A.
Greater than the amount which is
Yes,
mentioned in
yes.
the notification.
Yes, sir. But it's not there, your lordship. Nothing has been commercial quantity, it's not there, your lordship.
It
Commercial.
is apparent then when 6.8 kg of
Six,
heroin.
but see, whether 6.8 kg was the drugs or not, that is not been clear. If you see the FSL report, quantity is not there. What is your lordship? It's not the volume, it's the quantity of drugs which is relevant, your lordship, not the husk. The drugs is important, your lordship, because if you take the husk, it is all husk. And their report doesn't say what is the quantity, because they are asked a specific question. What is the percentage? They have not replied to that. This question is very clear. What is the purity of the items? This thing. Please furnish the estimated mark value of this thing. These are nothing has been replied to the CFS report.
My lord, sorry for interruption, but lordship, I pray that the paper compilation which my learned friend has submitted to your lordship, he has not furnished the same to me.
That is your record. That is the record which is your charge sheet record.
If that is the case, he has to show it from the petition itself, not in a
You are
separate
referring to
compilation.
the paper book.
No, I have the paper. That is their document.
No. What I am saying.
Yes, sir.
You have compiled a paper book.
Yes, sir. No, I have compiled an index because that whole
But
document.
you are referring to pagination of that paper book,
Yes, sir.
which
Yes.
PP may not be knowing.
He has
because
not
he
given
does not have a copy of that paper book. So if you are referring to your compilation, she is in dark to which paper you are referring.
I'll give you the index. Index will I can send the index.
He has to
Index I can send it because that all documents are there. It's all compiled together. D1, D2, if the lordship see the index. Only the names have been given. And for convenience, the page data, she has all the record. She has submitted filed this document, and I got it photocopied that whole document as together as it is. I can send her the index. Index I can send it, no problem.
No, your lordship, if at all he is submitting to the court, then he should serve me a copy.
It is with you already. This is your document, not my document, my friend.
No.
It is my document also. Then he has to show it from which petition he has.
Otherwise also, this is only reply to your submission. So you cannot, please don't repeat the things.
No, I'm not repeating.
You are repeating.
No, I pointed out which are not been dealt with. That is why I pointed. I am saying that which are not been dealt with by her. My learned friend, your lordship. Then, your lordship, I just take your lordship to the judgment referred by my learned friend. Your lordship, judgment referred by your learned friend, your lordship, to judgment. I just. Because one judgment my learned friends referred is 2014 5 SCC 108, your lordship. My learned friend has referred to para 21 only. That is regarding investigation, your lordship.
2014 5 SCC.
SCC 108. 2014 volume 5 SCC 108.
Yes.
So if your lordship see para 17, not 21 alone, para 17 of the inverted, para 17 if your lordship read. Para 17.
Citation.
Judgment confirmation.
Yes.
Para 17, my lord. The investigating officer and the prosecutor involved in presenting the case have miserably failed to discharging their duties, your lordship. They have been instrumental in denying to serve. My lord has got it. Para 17, your lordship.
Yes.
Failed to discharge that. They have been instrumental in denying to serve the cause of justice. The misery of the family of the victim of Gomi has remained unread. The perpetrators of a horrendous crime involved extremely ruthless and savage to the victim has remained unpunished. A heartless and merciless criminal who has committed extremely heinous crime has gone scot-free. He must be walking around in Amero or some other cities, town in India with his head high. A criminal is on the move. Fearless and fearless now because he could not be administered punishment he ought to have been suffered. And features on account of having remained unaffected by the brutal crime committed. His action now has no variance. He could be expected to act unfaithful service to them. Now, para 2021, my learned friends referred, that is giving a legal provision, Your Lordship. Para 21, the situation here, my learned friends referred to the situation referred to have been to be remedied. For
No,
what
no,
said?
what is your counter to this?
Counter, yes, I'm the 23 pages because this. Why I say I am not denying the principle, but it, whether this judgment is they are not resistant to her. That is what I'm saying. Para 23, if your Lordship will see. On the culminating of a criminal case in acquittal, the investigating prosecutor officer concerned is responsible for such acquittal must necessarily be identified. A finding needs to be recorded in each case where lapse of innocent and blameworthy. Each erring officer must suffer the consequence of his lapse by appropriate department, wherever so and so. Taking into consideration the seriousness of the matter, the official concern may be withdrawn and investigated response permanently or temporary dependent period. We also feel compelled to record the adoption of indecent measures which may reduce the malady of suffered parties. Both sides. According to direct the Home Department of every state government to formulate procedure for taking action against the erring investigating prosecutor. All such erring official identified for failure of prosecutor on account of sheer negligence or because of culprit must be suffered departmental action. The above mechanism formulated seriousness of performance investigation and would ensure that investigating prosecutor are painful device. The instant case I shall be given to effect. Your Lordship, this is reinvestigation of the matter. It's not no concern with this our case, Your Lordship. Then on 482, Your Lordship, my learned friend has relied on this judgment, Your Lordship. 482, Your Lordship, 2016, 6 SCC, 310. My learned friends relied on 14 to 16. That lays the principle of questioning, Your Lordship. That I'm not disputing it. But in this case, you have to, Your Lordship, see para 12. My Lord has got it. 2016, 6 SCC, so and so.
Yes.
In the absence of any act pursuant to the website by which he has been deceived by any person fraudulently or dishonestly induce any person deliver any property to any person, we find that it's not possible to achieve with the intention of cheating with the engagement of the section 14. Then 14th state of Haryana is that the Bhajanlal judgment has been referred to, Your Lordship. I'm not disputing that the legal provision I've done. Then coming to para 17, Your Lordship. Para 17, the entire law in the was reviewed by 3 judges, Bendako and Mohanlal sir. The law is retained by Mehta versus para 15 and 16. In all the cases, the principle of the accused must be relieved from the prosecution, even if the allegations are taken on the face value and accepted in the entirety, do not consider has been upheld, thereafter so and so, Your Lordship. So entire value, you have to see what is the material that on that. Then para 19, if Your Lordship will see, in view of the finding above, we find that no offence is made on section IT Act. This para 19 also. Then para 20, the High Court seems to have overlooked that the circumstance and has merely dismissed the petition under section of, on the ground it requires evidence on a trial to come to a conclusion. We however find that criminal indicted by the continue to abuse the process of the court and so and so. So here it is supporting me, Your Lordship. This judgment. So then, Your Lordship, then, in respect of conscious possession, Your Lordship, in case of NDPS, conscious possession, she has referred, my learned friend has referred to a judgment of 2011. But basic judgment I have given you a basic judgment which is on conscious possession is 2010 that I've given that judgment. 2010 9 SCC, it is not there. I think I give 2010 9 SCC 608, Your Lordship. Regarding conscious, what is conscious possession, Your Lordship? So here, if Your Lordship go to para 13. Para 13, it says, it needs no emphasis that the expression possession is not capable of precise and complete logical definition of universal application in the context of all statutes. Possession, my Lord has got it. Possession is a polymorphous word and cannot be uniformly applied. It assumes a different color in different contexts. In the context of section 18 of the Act, once possession is established, the accused who claims that it was not a consensual has established it because it is within his special knowledge. Then section 54 of the Act, presumption of possession of illegal article. This is there. The 15 says, from a plain reading of the aforesaid provision, it is evident that it creates a legal fiction and presume that a person in possession of illicit article have to commit an offense in case he fails to account for the possession satisfactorily. This is what possession a mental state of the and gives the statutory recognition culpable matter. It includes knowledge of the fact. The possession therefore has to be understood in a context thereof, and which tested on the anvil, we find that appellant has not been able to satisfactorily account the possession of opium. Now, your lordship, here things a very important issue is here. Your lordship, here you have to see the possession, conscious possession. Now,
Yes.
now your lordship, conscious possession here. It is a fact. It was kept in custody to me, and it is not there. And the entire thing, it is not recovered from me, Your Lordship. It is recovered from someone else.
That you have already.
Yes, that's particular because how this judgment is helping me. I'm just because you cannot establish possession in me here, sir. Possession. Then para 22 of this is also important. Para 22. Bearing in mind the aforesaid principle, when we consider the fact of the present case, we find that prosecutor intends to prove that the appellants were in possession of the opium by disclosing that illicit was recovered from the dicky of his vehicle, driven and occupied by him. Possession is a mental state. And what has been unfolded to prosecutor is that the search of the dicky tiger of opium recovered. Circumstances aforesaid lead to the conclusion that the appellant were in conscious possession. Therefore, it cannot be said in untold experience so and so. So here it cannot be a conscious possession of the whole thing, Your Lordship. That is my respectful submission, Your Lordship. Then, Your Lordship, the learned friend has referred to the judgment on 2011, the same thing, 2011, 11 SCC 347, Your Lordship. My learned friend has referred to para 24 only. That's the principle. That 21, 22, it is also important, Your Lordship. Now we proceed to consider the last question, whether the appellant can be guilty of being in possession of the involved selling and attract mischief of section 8 and 18. In sum and substance, the confusion of the appellant is that he was working in the hotel for the last 2 months and brought the opium from the house of a hotel owner in the hotel, where it was being sold in tablets to truck drivers. In the confession, the appellant has not stated the matter. None of the witnesses have deposed that he was involved in selling opium tablets. Therefore, the appellant cannot be held guilty of selling opium. 20. Whether the state of evidence, the appellant can be held guilty for possessing the opium only on the ground that he has brought the opium from the house of the. Then, Your Lordship, this para 24 is my reference, right? It is tried that you whole person guilty possession has to be conscious. This is very important. Whether it's conscious or not. Control over the goods is one test to ascertain conscious possession so as to title. Here, the control is not there, Your Lordship. Once an article is found in possession of an accused, it could be presumed that he was in possession. Possession is a polymorphous term which can carry different meaning in different contexts and circumstances, and therefore it is difficult to lay down a complete logical and precise definition uniformly applicable. Also, with reference to all these statutes, a servant of a hotel in your opinion cannot be said to be in possession of contraband belonging to his master unless it is proved that he is left to the custody of. Here, Your Lordship, the drugs belongs to the department LCB, not to the IGP, Your Lordship. Just kept in his custody. Then, applying the aforesaid principle, we consider the facts of the project. It is difficult to hold that opium was in possession of the appellant. There is no evidence on record to suggest that the appellant was in occupation of a room from where opium was recovered. Further, the evidence clearly points out the title of the opium vested on the owners of the hotel. The confession given by the appellant was only that he was servant of the owners and the hotel for whom the opium was recovered. In face of the state of evidence, it is difficult to hold that the appellant was in conscious possession of the. Section 18 of the prescribed punishment for possession of a present case is difficult to hold the appellant was in possession so and so. So, Your Lordship, clearly it shows conscious possession is not there in my case. Then, Your Lordship,
Mr. Chaudhary, we are done with time.
I took some more time of judgment.
How much time you?
Another hour, Your Lordship.
No, you will not get so much time.
Because the judgment, I have to deal the judgment.
She has cited only 5 judgments.
No, I have also some judgment which I have to cite.
No, but in reply.
No, judgment, I have to show that how the offense of 409, 420 is not, because I have shown.
You are only replying to her submission.
Yes, I am replying, because, and I have
You
to,
have made your submissions.
I have to show that for how.
To your submission, she had replied.
So how 409 and 420 is not attracted here. That's why I have to show that. 40, because here 409 and 420, because the judgments are there, your lordship. Because
No, but you have to assure me that this cannot go on endlessly.
no, I am not saying enlightenment. Just 1 hour I'll finish it up. I'll finish. Give me another day after tomorrow, I'll finish it. Your lordship.
We cannot accommodate you on day after tomorrow. We have already, because
Then Tuesday, your lordship, Tuesday. Tuesday I'll finish it up.
But in that case,
because you have seen for
I know,
accommodating.
I understand your lordship difficulty. I know, I fully with you. But day after, Tuesday, I'll finish.
It has to be after Bihu.
No, your lordship, finish it, because I have to finish it up and go, your lordship.
No, you are not inclined to finish.
No, I have to be, in fact,
Because I am giving indulgence to you.
No, no, your lordship, give indulgence to, I know that your lordship, give me, your lordship, day after tomorrow, I'll finish up, anytime I'll finish up, day after tomorrow. I'll finish.
Lordship, my presence may be dispensed with because I have other matters.
Day after tomorrow, I'll finish it off. I'll just give you, I'll finish it off. Let us finish it off once
I have
more.
already submitted my submissions. So my substance of the submission is that on the face value of the records.
And you need not to reply because your reply is over. You
So,
can.
So your lordship, my presence may be dispensed with. Let the petitioner counsel submit.
Day after tomorrow, I'll finish it off. I give it a leadership. I'll finish it off.
No, day after tomorrow, we may not accommodate. Because day after tomorrow, NCB matters we have fixed.
Then Tuesday, your lordship, Tuesday, your lordship.
We'll fix on 19th.
19th, too late, your lordship. Yeah. No, no, the day, next Tuesday, I'll finish up and go. Because I just waited for this.
This week has been declared as.
No,
motion.
next Tuesday, coming Tuesday, your lordship, I'll finish it. I'll take half an hour, 1 hour, not one more than. I'll finish it.
Sorry, Pandey.
I'll finish it off, your lordship. Tomorrow, if your lordship can accommodate, I can do tomorrow.
No, it is not at all possible.
Or Friday.
Heard Mr. P. Chaudhary, learned senior counsel assisted by.
Peter.
Motion with to Peter Pakitari. It has to be after 10. After 10, because this week we cannot adjourn motion matters
Your lordship is fixing when.
after Bihu.
Oh, it will be very difficult, your lordship. I'll finish it off now.
No, you have made your work difficult. You have been given sufficient time.
No, because your lordship, your lordship is giving time, I'm not disputing it, your lordship. The lordship, give me
You
Tuesday
cannot
or.
argue for unlimited
No,
duration.
no, Tuesday, you give me, I'll half an hour.
Tuesday, you will not get time.
Tuesday, yeah. Then Thursday, give me your lordship, Thursday.
Mhm.
Coming Thursday, not this Thursday, coming Thursday, your lordship. I'll finish it. Thursday, I'll finish it.
Half an hour only,
Okay.
at 4.
Okay.
I heard Mr. P. Chaudhary, learned senior counsel assisted by Mr.
He says he's in lecture. Yes, he was having violent fever today.
What is the name?
D. Talukdar.
D. Talukdar, learned counsel for the petitioner. Also heard Miss V. Sokre, learned public prosecutor. Okay.
I hope the date is recorded correctly. master that problem.
This is Kohima matter. Heard Mr. P. Chaudhary, learned senior counsel assisted by Mr. D. Talukdar, learned counsel for the petitioner. Also heard Ms. V. Sokre, learned public prosecutor Nagaland. The reply by Mr. P. Chaudhary, learned senior counsel, could not be completed, and hence let this matter be listed again on Thursdays. No, not this week.
Next 11th, yeah.
It's holiday.
Yeah,
Okay.
to that.
On 10th, on 10th, on
Your
10th,
lordship, holiday, your lordship.
10th, 10th.
Then is, you know,
division bench.
Yes, DB, division bench here.
4 o'clock, her DB won't be there till 4 o'clock.
Then, your lordship, in that case, my appearance may be this
Yes,
presence.
on 10th of April, on request of learned public prosecutor Nagaland, her presence on that day is dispensed with. Let this matter be listed at
3:30.
no 3:30, at 4. We are not giving a time.
No, why I have to, because I don't know detail your lordship. That's it.
4 to 4:30
I have no problem.
at 4 p.m.
I have no problem. I have no problem.
Because we have adjourned many matters
No.
today for.
I understand the problem. I understand the problem. Deeply obliged, your lordship.
Item 14, my lord. I'm just not.
22,
Yes, lordship.
he has completed statutory period.
Today also we have received a case there.
Already statement completed, lordship.
So your prayer is allowed 30,000.
Okay, obliged.
I will pass orders in chamber.
My lord.
Yes,
My lord, CD not required.
CD not required.
Right.
Because here
My lord.
completed statutory period of detention. Offenses under section.
406 and 420.
Okay.
Date
Your
of
prayer
arrest
is allowed.
3-2, my lord. Date of arrest 3-2.
Okay.
2-2, forwarding on 3-2. 3-2. In Alipurduar.
Yes. Next.
Obliged.
My prayer is that item 14, can it be taken up tomorrow, my lord?
What is the matter?
14, my lord, it's a 439 application, my lord. 14.
NDPS, my lord, perhaps.
Okay. Okay, tomorrow.
MTP of it.
Item 13 is fixed on 9th. Can it be at 2 p.m. on that day? It's a hearing matter.
2 p.m. we have difficulty. We'll take it up.
At 3.
You on the morning of 9th you mentioned.
Highly obliged.